Okay. Okay, folks. Oh, thin crowd, not bad. Good afternoon. We have, according to my notes here, 4.5 hours argument time. That takes us to about 6:30 tonight. I don't know, I think you folks might want to do something other than be here. 6:30. That said, you know the usual language, so standard speech. We know, we've read your cases, we know what's going on. Please ask for the time that you believe you need to get your point across. Remember, the clock is for you, not for us. That said, first case up, People versus William Matthews. You're by yourself? No. Who's the respondent? No respondent. Okay. Yeah. Okay. Yeah. You're arguing on yourself. You want to submit, or you want to still make a? Okay, I'll give you 4 minutes. You don't need rebuttal time. 4 minutes. Okay, on the first one. Second case, Hartigan versus Gilbane. Well, you need 8 and 2. She said 5 and 2. Okay, all right. Oh, I know. Okay, what would you like? 6 minutes. Okay, you know what? 5 and 2, 5 and 2, and I'll give you 5. Okay. Leroy W versus Shaniqua W. That's submitted. Richard versus 155 Realty. I'll give you 4. Okay, so we got 5, 2, 4, and 4. Thank you. Allen versus ZZ Construction. Get 5 and 3 and 5. Thank you. U.S. Bank versus Tabinia. You got 5 and 3 and 5. Thank you. O'Connor versus Society Pass. All right. We got 5 and 3 and 5. Thank you. This has to do with the warrants, right? Yeah, okay. People versus Paris Roberts. 5, 2, and 5, thank you. Fleischer versus Zhang. 7? So I'll give you 6 and 3 and 6. Thank you. Caputo versus IESI New York Corp. I'll give you 5, 3, and 5. Thank you. All right, People versus Pernell Liebert.
Appellate request 8 and 2, Your Honor.
All right, I'll give you 6 and 2 and 6. Thank you. Geico versus Goins, that is submitted. First case up, People versus William Matthews. Okay, you're up.
Good afternoon, Your Honors. On behalf of Mr. William Matthews, Phoenix Rice Johnson from the Center for Appellate Litigation, because of the ample mitigating evidence in this case and the unusual circumstances of the offense, we are asking that Your Honors find this sentence excessive. Mr. Matthews punched a man 2 times and was sentenced to 12 years in prison. This was his first ever criminal conviction at the age of 30, and he has an IQ around 70, putting him in the bottom 2% of the population.
But there was information in the record that established that he functioned very well in the commercial setting as a manager of the business, training, tutoring other workers. In fact, this was used to to build him up in terms of his credentials. So I don't think the IQ is a real issue. What's troubling to me is that when he and his brother went back home, or when the brother came back home and the victim followed, there was no reason to leave the apartment. If there was a concern, they could have called 911, that they affirmatively went out there, and that he played a very active role in beating up the victim, and of course, his brother stabbed the victim, and he had the knife, so that was really an intentional act out of anger, and someone died. So I don't quite see why you think it's such a marked reduction here.
There's no doubt that the conduct in this case was serious. However, Mr. Matthews was home with his 3 young children and his special needs nephew when his brother entered the door and said that a man had pulled out a knife, threatened to stab him, and followed him all the way home. And with this context, Mr. Matthews followed his brother outside and with the intention of confronting the man, and in the course of about 5 seconds, punched him. And to be clear, this is Mr. Matthews' first ever criminal conviction, and his IQ really is in the bottom 2%. While it is truly incredible that he was able to have such an impressive work history.
Counsel, didn't he waive his right to appeal?
Yes, Your Honor, but
So why are you here?
because of his meaningfully diminished cognitive capacity, the fact that this was his first ever criminal conviction.
Has anyone ever said that he was unable to validly waive his right to appeal?
No, Your Honor, is not.
Oh, okay, so why are you here? He waived his right to appeal, and that precludes excessive sentence, right?
Your Honors, in People v. Bradshaw, the Court of Appeals found that the waiver was invalid in part because the defendant had mental regression. And in People v. Perkins, the third department, the site there is 152 AD 3D 1072, found that the appeal waiver was invalid under very similar circumstances. The defendant.
Wasn't there the discrepancy? There was one report that said that he had those issues, but then at the pre-sentence report, he never raised those issues. He kind of like, it was a totally different, it was literally night and day in terms of the 2 reports about his capacity and how he understood things. So again, how is the sentencing court supposed to take that? I mean, you got 2 different views of an individual now. As my colleague said, you know.
I hear you, but the records in this case are ample. He had his IQ tested multiple times, and it consistently showed that it was near 70. Mr. Matthews did not speak extensively with probation. There's much less in his PSR than there is in the remainder of the record, but even probation noted in his pre-sentence report that Mr. Matthews, quote, actions in the instant offense do not appear indicative of his usual mode of behavior.
No. We're talking about the waiver. He waived his right to make this argument. And in fact, he said, right, I'm sure you've had adequate time to discuss with your attorney your right to appeal. Have you not? And he said, yes, I have. So it's not only just that he waived it, his attorney could have, but did not bring any of that up at the time he waived, right?
That's right, Your Honor.
Okay.
May I make one
Thank you.
final? Okay,
Okay,
thank you.
thank you. Hartigan versus Gilbane. Please. Okay, you're up. Thank you.
Good afternoon, Your Honors. May it please the court, Lauren Turkel for the appellant, Hudson River Park Trust. This case is not about the failure or inadequacy of a safety device. This case is about plaintiff's sole failure to exercise common sense in the happening of his accident. This is not a case where the device was malfunctioning.
This is the scissor lift, right? That's the safety device in general, right? Because you
Sure.
need that to get up to the top and so forth to work on. And the way that I read the record here, as he is leaving or getting off that cab, he slips on one of the rungs that was wet, right?
Allegedly, yes.
Allegedly, okay.
There is some evidence to dispute whether or not it was in fact wet, but that is plaintiff's version of events as the movement that he's put forward. However, he's not working on the man lift. The man lift is not elevated. He's not raised. He's alighting from the back of the man lift. He allegedly slips on water that was present before.
Is there a safety device which could have prevented his fall?
Not unless one would consider a paper towel to be a safety device. I don't think so. This is a complete lack of common sense on the part of the plaintiff. If we're to believe his version of events, he finds the man lift set up by his coworker. He notes that some water has dripped from the ceiling. He does not alert anyone. He does not get
What do
a
you
paper
mean
towel.
why shouldn't we believe him? What evidence is there contradicting what he had to say?
Sure. Well, there are a number of incident reports and a daily log that do not note rain and note.
Okay, but that's not inconsistent, right?
Sure.
So what is inconsistent with his version of the offense?
Yes, Your Honor. It would be that plaintiff claims that the dripping water came from rain that morning. The pipes were turned off for the sprinkler project he was working on, and the weather expert says that it would be climatologically impossible for there to have been rain dripping.
And
through the
didn't he
parking
put
deck.
an affidavit in from one of his coworkers saying that there were drips at that point all the time?
Yes, a coworker who.
So wait. So the plaintiff says it was wet. His coworker says it was wet. And your response to that is that a meteorologist acknowledged that it was rainy and cold, but said it wasn't enough to make the stairs wet, and that's how you think it's contradictory?
No, Your Honor, that's not how I
Okay,
think it's
so let me hear
contradictory.
what it is.
Yes, so the plaintiff assigns the dripping water to the rain. There are no other sources from which the rain could come because the sprinklers are turned off. Our expert says that would not have been a source of dripping water, and the coworker claims to be an eyewitness to the accident, which the plaintiff denies. The coworker claims it was a very cold day, when in fact it was a 70-degree day, and the weather is described in the daily log as funnel clouds without rain. So plaintiff is the movement. He has the burden, of course, and there's just a number of inconsistencies here. So you're really dealing with two different issues. One is the multitude of inconsistencies in how and why this happened, and the other is the fact that if it happened, how plaintiff claims that it did, there's at a minimum a question as to whether he's the sole proximate cause of that accident. Thank you, Your Honors.
Thank you.
Good afternoon, Your Honors. May it please the Court. My name is Michael Kivard. I'm with Ropers Majeski. We're here representing Gilbane Building Company, the construction manager in
Right,
this.
your point is, your client is the construction manager. I'm not the statutory, the facts here don't bear out or support that I'm the statutory agent of the owner or GC, right?
In a nutshell, yes,
Yeah,
that's
right?
correct.
I mean, there's nothing in the contract here that says that I have the authority to control, supervise, and do a lot more than what the contract tells me I can do.
In fact, I agree, Your Honor, and in fact, it says exactly the opposite. It says you are not to act, and you are not the agent of the building owner.
But it did say that you have oversight over safety and review the safety plans. And while you take the position that perhaps you're not as hands-on with the means and methods, it conceivably could be an issue of that as to really appreciating the full scope of Gilbane's role here, correct? Because nobody else is there but Gilbane.
I mean, there was certainly, well, that's, yes and no. I mean, Gilbane was there as the construction manager, but remember also,
Well, PACE, you don't have, wasn't the third-party action discontinued?
yes,
So if it's discontinued, I don't know how much an empty chair is going to work with this. And it's certainly Hudson and the other, it was not there involving the means and methods. It's really Gilbane and PACE, correct?
yeah, and if you look at the PACE contract documents, the ones they signed with the trust, it says PACE is responsible for means and methods. And an additional paragraph specifically says that the architect and the construction manager are specifically not responsible for those things. So it covers it from both sides.
What number of contracts? There's a contract between Gilbane and Hudson, right?
That's correct.
And there's also a contract between Hudson and Pace.
Yes. And it's, I think, does us all a disservice to only look at one contract and not the other contract, since both bear on the outcome here. Thank you, Your Honors.
Thank you.
Good afternoon, Your Honors. May it please the Court, Christopher Della Carpini for the respondent, Mr. Hartigan. I'd like to begin with a question.
It's in part your position that Gilbane is responsible for safety here, is it not?
It is, Your Honor. I think
So is that covered by page 74 of the record?
Article 19 of the
Contract between Hudson and Gilbane?
that's one of the places that covers it, yes.
So what there makes Gilbane in charge of safety? What is it? I think it's task 19, safety, right?
Yes, Article
Page
19.
7, yeah, so what in there makes Gilbane in charge of the safety of someone such as the plaintiff?
Well, as Mr. Nuschler, Gilbane's witness at deposition, explained when we walked him through each of those.
So Nuschler testifies at page 692, is this, but Gilbane had, in managing, had some responsibility with regards to safety. Is that true? And the answer is just compliance, just ensuring that Pace complied with their health and safety plan.
That's exactly right, Your Honor. They were responsible for ensuring that each and every contractor on site was in compliance with safety. As Gilbane pointed out in their reply
And wasn't
brief,
their role then to report on that to Hudson?
that was part of their role, depending on the compliance of the contractors. Like Gilbane said in their reply brief, it is all about control.
This wasn't really a contractual situation, or was it, that Gilbane had the authority to stop the job if they didn't like the way it was going in terms of Pace's work?
I think it's undisputed that Gilbane had that authority. It comes in the incident report from Gilbane's own superintendent. This is page 1237 of the record. The superintendent writes, "A stand-down will be held to discuss how to safely exit a scissor lift. If you can stand down the contractors for safety reasons, you control safety." Gilbane doesn't want to be called a contractor. They want to be a construction manager, as the Court of Appeals said in Walls. These labels are not determinative. It is all about control. Gilbane exercised that control. The contract language supports that exercise of authority, but there you have the exercise of it. They showed that they were in control of safety because they exercised control over safety.
Counsel, how do you respond to the argument, 1550s or argument that the plaintiff was the sole proximate cause of his injury? There's a question of fact as to that.
Yeah, why didn't he use a towel? Why didn't he say to somebody, "Hey, could you clean this up for me?" They say sole proximate cause. They're really talking about contributory negligence, which is not an available defense here. To prove sole proximate cause, the defendants would have had to at least raise an issue of fact on whether a proper safety device was available and whether Mr. Hartigan
So what
failed to
safety devices that you say should have been used?
use a dry ladder.
So the harness
Operating
plays,
device.
I'm
Not a
sorry.
harness. I can explain that if I.
So he wasn't supposed to take the scissor lift down. He wasn't supposed to use the staircase that was part of the scissor lift. Is that what you're saying?
We are saying that the owner and the contractor, the defendants, had a responsibility to provide proper protection, a dry ladder. It's undisputed under the record that he slipped and fell because the ladder was wet.
Well, so that's, I guess, what counsel was just telling me, that it is highly disputed whether the ladder was wet. So I'd like to have your response to that.
Yes, the expert opinion of Mr. Wright, who downloaded some data from the internet and told us, how did he put it? I want to get this right because I didn't see it climatologically impossible. What I saw him say was, here it is, any wetness or moisture that may have been present anywhere on the second floor of the subject parking garage did not form by way of the insignificant rainfall. Okay, he doesn't even say it wasn't wet. He doesn't say there wasn't moisture. He's opining on where it came from. Who cares?
Wasn't there,
It was there. This is why we have the labor law, to stop taking time with these questions. It was the defendant's responsibility to
Well, if
provide
that were
a
the case,
dry
we
ladder.
wouldn't have any appeals.
I know.
Go ahead.
I mean, you still have to prove that it was wet, and counsel is saying that there's an issue.
well, one second, wasn't there something in the record by Gilbane's Mr. Nuscheller where he said that water could still leak during
Absolutely.
work, even if the sprinkler system was shut off.
Yes, it is all possible. It is
This is
undisputed.
Gilbane's own witness.
Yes. Yes, he was most helpful to us. He walked us through the contract, he walked us through the moisture.
You say,
Go ahead.
Just one follow-up earlier. What's the role of the harness here?
That's an excellent question, Your Honor, and in that respect, they make much of it in their reply. In this context, we offered today the De Los Santos decision this court handed down on Tuesday, which I think is very informative. In De Los Santos, this court upheld summary judgment for a plaintiff in a 240 case when the plaintiff slipped and fell off a motorized scaffold. The plaintiff was wearing a harness. If you go back and look in the briefs in De Los Santos, he was wearing a harness.
but you say the safety device that should have been provided was a separate dry ladder, but the plaintiff testified seems to have said that he should have been provided with a harness.
Plaintiff thought he should have had a harness. He asked for a harness, and he was told not that you don't need a harness.
He
was
didn't
told
say
they didn't have
anything.
any.
He didn't say anything about having another ladder.
That's what he said at the time, yes. And maybe he's right. Maybe a harness would have avoided this. But it is undisputed on this record that the ladder he was provided with was not safe without a harness.
It wasn't a ladder. The safety device was a scissor lift, right?
No.
Now he had to alight from the scissor lift. And so he was using what we're calling a ladder, because I think in common parlance, that's what we would call it. Normally, though, when we're having this discussion in 240, the ladder is actually the safety device used to facilitate the work. Here, the scissor lift seemed to fulfill its core function of allowing the worker to perform the task safely, the sprinkler work. Now he's trying to alight from the scissor lift using this stair. So is a harness designed to avoid that type of risk, a risk from falling off a means of egress from the safety device?
I don't think it matters for this case. Maybe it would have, maybe it wouldn't. The enumerated device that was provided is a ladder. It's a part of the side of the scissor lift. That's what the pictures show. But that's a ladder, a thing with rungs that you use to go up and go down. That's a ladder. It's on the lift. That was provided. That's why it's on the lift. And that was wet.
And that's your theory? That's the 240 sub 1 violation is not providing a dry, safe ladder?
Yes, that's what we argued throughout our brief. It's defendants in reply who want to make this about a harness.
Okay.
Well, it's the plaintiff in his testimony that made it about a harness.
Oh, he asked for one. He believed it. That's his experience as an attorney. That's what they asked him about. That's what he testified to. We're here arguing the law, the labor law.
Great, thank you.
Thank you, Your Honor.
Well, that was an interesting pivot to the quote unquote ladder, which are actually the fixed rungs at the back of the scissor lift. It's unclear how plaintiff is arguing comparative negligence versus sole proximate cause. He arrives at this device that was just set up by his coworker.
Well, it's not unclear. If he sprayed the device to make it wet, then it might be a sole proximate cause. Or if his supervisor said, dry that off before you walk down, and he didn't do that. But this is not that.
Absolutely, Your Honor, except he doesn't tell anyone. He shows up, he sees that some water has dripped on it, he checks all common sense at the door, which the Court of Appeals has advised not to do, right, based on his experience, his expertise, and his knowledge in this industry and as a human being in general.
What the plaintiff's attorney is saying that there should have been another dry ladder there as a safety device for him to get down. What's your response to that?
My response to that is that it had only just become wet, allegedly. Again, let me be clear about the allegedly on that. And that rather than saying this is wet or simply obtaining a towel and drying it off, he chose to ignore that, okay? He chose to go up onto the scissor lift, complete his work, and come down on the very same condition that he had ignored and he would have easily been able to ameliorate with the exercise of common sense.
I don't know of another ladder, given how this device works and how it's set up and how it's designed. I don't know if another ladder separately apart from the machine is actually workable. But that said, I'm hearing his argument. If the whole contraption is a safety device akin to like a ladder, and there are cases that we have, if I'm not wrong, where a person alighting a ladder slips and falls. isn't that analogized to this situation?
So, Your Honor, in those situations, the ladder becomes wet during the course of the work. In fact, the case that he suggested in his papers, these are all cases where it's part of the work itself that creates the condition on which they fall. It's a very different scenario here, what has occurred. It's simply not the same. I would almost make this tantamount to falling off a flatbed truck, right? He's just getting off the back. And he falls,
So the wetness, what you're arguing is the wetness wasn't caused by the work that he was doing on the sprinkler system. The wetness was something unrelated to whatever the work he was doing. So that's your distinction between those cases where someone slips off a ladder versus this case.
It's two distinctions. That's one of them. The other distinction would be that the wetness occurred actively while the person was performing the work. Here, his testimony is that nothing fell, no new precipitation while he was performing the work. He gets to the lift, allegedly, notes that there is some water on the rungs of the lift. He decides to ignore it. He doesn't tell anyone. He doesn't get a paper towel. He climbs up to the lift. He safely and securely performs his work by his own testimony. And as he is climbing off the back, the same way one might off a flatbed truck, he allegedly slips on the same rungs and the same water that were already present.
Is the sole proximate cause standard for 240 more nuanced, though, under Gallagher than a more general sole proximate analysis in a negligence case? Gallagher lays out 4 or 5 elements to the sole proximate cause defense, I think they call it, in the 240 context, which is, do you satisfy each of the elements of the Gallagher formulation?
I believe we do, Your Honor, because this is, again, not a situation where the safety device was inadequate or failed. This was common sense. It's sole proximate cause.
So now I think, though, that's sort of blending whether there's a statutory violation with whether there's proximate cause, right? So either the safety device was adequate as it was provided, or the plaintiff was, despite being given an otherwise adequate safety device, the sole proximate cause of his injuries.
I think it's both.
Okay.
Thank you.
Thank you.
Your Honors, I'm glad the Respondents' Counsel came back to the issue of control because the court below cited Lind in support of its ruling on the agency issue, and the level of control over particularly safety issues in Lind was broad and all-encompassing. Whereas here, there were 4 paragraphs in the contract that talked about safety issues, each of which really amounted to a clerical task about gathering information and passing it along.
Your colleague claims that Gilbane had the authority to stop the job. Is there anything in the contract which gave Gilbane that authority?
Well, I don't believe it does, and in fact, I believe it's the opposite.
I don't see when you look at what's on page 74 and 19 that there's anything there which gives Gilbane that authority.
I believe that's a correct conclusion, and in fact, also if you look at the PACE contract.
It's about reviewing for completeness, monitoring, maintaining record copies.
It's essentially clerical, Your Honor, as I would see it. And you
I
also
don't know if
have
I'd go that far.
Okay. Fair enough. Also in the PACE contract, it says, the record to page 208, neither the construction manager nor architect responsible for construction is responsible for construction means, methods, or safety precautions / programs, since these are solely the contractor's responsibility. And in that context, the contractor is PACE. And of course, if you apply the Walls factors, other than the absence of a general contractor on this project, I believe the Walls factors favor ruling for Gilbane here. Thank you, Your Honors.
Richard versus 1550 Realty.
Good afternoon, Your Honors. Jason Steinberg, I represent Mr. Richard. The first question I want to address is the lower court gave too much weight to the fact that there were no measurements of this defect.
Yeah, because look, the way I read, unless I read the wrong record, which is probably possible, the accident happens. A week later, the sidewalk flag is repaired.
The sidewalk was
So
repaired a week ago.
how is it on earth then are you going to be able to prove your case to a jury, right? I mean, that's a problem, isn't it? And it's just so happens that there's another action that's going on where the plaintiff in this case here says, yeah, the photos that were used, the evidence that were in the other case, or the photographs of the sidewalk flag, he testifies that they're an accurate description or depiction of what he fell on or tripped on, right?
Correct.
So how, I'm just wondering out loud, it's like where you're at with this case. I mean, if you don't,
As far as the status and
yeah, well, no, status, in terms of, what else can you do to prove it? You've got to you have the evidence from I mean, this is very unique in that. I've never seen something like that where.
I think it was a matter of circumstance. We got lucky almost. Okay, but that being said,
Yeah, I know.
but that being said, the plaintiff estimated the measurement because he saw it when he got up and he fell. He got up. He was able to see. Oh, yeah, it was about 1.5 inches. He testified to that. That was based upon his own personal observation.
But isn't that, so I think, okay, that's, could be, but could not be. It's not, there's no matter of law that 1.5 inches is per se negligence, right?
Well, it's evidence of it's a violation of the administrative code.
Which is some evidence of negligence,
That is
but
true, but the
doesn't
trial
even
court-
get you to prima facie.
Because there's a couple of reasons there's prima facie. Not only the measurement that he gave based on his own personal observations, but based upon the photographs from 2 years or a year earlier on that case where the tenants emailed to the property manager, there is a defect in front of my property. It is sinking. It is a 1/2 inch to 1 inch low, or the depression, or the elevation rather. That is a measurement that is consistent, not exact with my client, but nonetheless still a violation of the
Did the
administrative code.
condo put in any evidence to say that it wasn't a defect?
I'm sorry?
Did the condo put in any evidence to show that it wasn't a defect?
Defendant submitted 0 evidence to challenge anything that was
Yeah,
said.
because you're prima facie. You have two things to prove on your prima facie: the defect and notice, right? I mean,
Yes.
that's essentially what you got to prove.
Yes,
And in
we have
this-
both of those things.
Yeah, because the notice, as far as looking at the record, is the other action that was filed a year earlier, right?
Yes.
That's the notice part.
That's actual notice right there. The tenant complaints constitutes actual notice. Furthermore, let's just say the actual notice was a little unclear, but at least it's there. Now it's a year, so it's constructive
You have
notice.
the accident from the year before, which is an aggravating circumstance in your favor.
It's a proving circumstance in my favor. Now Tropper is the case. I want to get the Tropper case because this court specifically held you can establish prima facie case, or a plaintiff can, based solely on their observations of a defect and their calculated measurements, supported by photographs, provided that the defendant cannot refute what you're saying. That's what we have in this case. Why didn't they get an affidavit from somebody from the condominium to say, we've seen that before. There was nothing, we measured it, there was no reason to repair it. We got the complaints from the
Define
tenant.
a defect or a hazard or a danger in this regard.
It's a danger because the tenant, in the complaints, in the email, specifically said, this is a trip hazard, and somebody else
Okay,
tripped.
but that's sort of a conclusion that something is a trip hazard. As a matter of a law, there has to be a standard for what's a defective condition, an actionable condition.
Okay.
So what made this particular condition defective? And defective to such a degree, we could say so as a matter of law.
Well, when you consider the transient factors or the surrounding facts and circumstances, you have a gentleman walking on a sidewalk, he's looking straight ahead. You have a defect that violates the administrative code, which is evidence of negligence. You have tenant complaints from a year earlier specifically stating this is a trip hazard. You have a complaint from a previous lawsuit stating I tripped over this defective condition. On top of the fact you have consistent measurements provided by a tenant, somebody completely unrelated to my client, both coincidentally giving measurements that violate the administrative code.
And on top
That's
of that,
prima facie.
And on top of that, you're not going to be able to do anything because whatever defect, alleged defect there was, it's gone. Somebody repaired that flag, right?
Correct. The assumption in this case would be it was All Area, the management company, because the complaints were made to them. And I believe in the affidavit the tenant submitted, that the co-respondent submitted, the tenant said, I think he said All Area did the repairs about 2 years ago, which is consistent with the time my client's accident occurred. So that's on them, you know, to come back. All I can do is give you a measurement my client gave and support it with the tenant's measurements. Now the burden shifts to them to say, there was no defect here, but they can't do that.
Okay, thank you.
All right. Can I say one more thing?
No, you got rebuttal time. Somebody get up. Draw straws if you can't figure out who goes. Don't worry, we're not mean.
Good afternoon, may it please the court. I represent Washington Bridge View Condominium, WBC Apartment Corp., and All Area Realty, Inc. I will say that the eyeballing of by the plaintiff is not sufficient to show that we have under Hutchinson.
Let's put it, assuming that, you know, I buy the argument, what did you come up to oppose the motion for summary judgment? Because in this case here, arguably, the notice is there because of the prior action. I mean, this is really, I've never seen a case like this where the evidence is based on another action in the same area, right? So you have that notice, I think, is pretty much their prima facie, they satisfy that. And in terms of the defect, now that's the question, right? Was it a defect? But you have the evidence from the prior action where they have the photographs, they have everything that's there. And in this case here, if you were to say, Judge, somehow, some way, let's say we agree with you and we agree with Supreme Court and sends it to trial, how are they going to be able to prove that defect? Because whatever defect was there is no longer there. It's gone. Somehow somebody repaired that flag, that sidewalk flag. It's where we're at. They're going to lose, right?
Well, the interesting part in this case is what we have is the emails that plaintiff relied on from the other case. And the April 30th, 2018 email says we're fixing it. And then you have an affidavit that was also submitted in that other case that said about 2 years ago we fixed the flag. And then you have the plaintiff's testimony where he says it looked like it was a new flag. This flag was a different color and it looked new. So now you have the plaintiff who lives in that building come back a week later.
You're saying that the flag got repaired before his fall?
Absolutely, because, and this is a question of fact, this needs to
No, what did you put in to raise that? What evidence did you put in to raise that issue of fact? Did you put in anybody, the contracts for it?
We did not put in any.
Exactly. You can say what you like, but what did you put in? The plaintiff said when I fell, it was 1.5 inches, clearly violating the administrative code. What did you put in opposition to that?
We were raising an issue of fact.
No, you can't raise an issue of fact by an attorney's affidavit. What did you put in to say that there was a question of fact as to whether or not that was the correct?
Or it was repaired?
Right, repaired before his accident.
Well, what we had in evidence was the pictures that show that it was repaired.
After his accident.
Counsel, it's simple enough. If you are claiming, as I'm hearing you, maybe I heard wrong, that flag was repaired before his fall, before the trip and fall, it's simple enough to get the contract or the contractor saying, or an affidavit in the contract saying, on X date, I repaired that flag, and that's before his fall. Do we have that in the record?
We don't have that in the record. What we have in the record is the plaintiff did not put in a sufficient prima facie showing.
Well, assuming that we think the plaintiff did, because everything that the plaintiff has said so far is uncontradicted, what did you put in to dispute it?
So the only things that are in evidence that I have in the record to work with are exactly what plaintiff put in.
No.
We don't have a contract from somebody repaired it. Someone has a contract that wasn't in. You didn't get an expert to say that was in de minimis. You didn't put in any expert testimony, right?
Either did plaintiff put in
No,
expert testimony.
I'm not talking about plaintiff. You're saying, I'm asking you what you put in. You didn't put in the contract showing that it was repaired before his accident. You didn't put in an expert affidavit. Did you put in any affidavits or documents?
There were no affidavits or documents put in. I will point out that what plaintiff's evidence was supportive of our position. supportive of our position in the fact that there was some sort of repairs that were done, that there's a question of fact as to whether or not the plaintiff himself didn't fall on a defect that he was claiming as 1.5 inches, that what was depicted to say a year earlier is a 1/2 inch or another or an inch was not sufficient to show that it's even consistent. It's not consistent with what plaintiff says. It's not consistent with our client says.
The bulk of your argument, as I understand, is essentially nobody bothered to measure it. That's really what you were arguing. But as my colleague pointed out, how could he have come back the following week to measure it? You certainly didn't. And one of the other points in the record was that it was a sinking sidewalk. So even if you did a repair, and again, we don't know that, the flag could have still sunk in the time period. We're not talking about 3 months earlier. It's quite a bit of time between the last accident and this accident. And you did nothing, as was pointed out, to really controvert it except to make legal arguments. And moreover, much of your argument, at least as I saw in the briefing, as to whether the emails are hearsay, and that's a fair argument, but you didn't raise it below.
Well, it was raised by the judge raised the fact that there was no foundation for either the photographs or the emails, so that was raised below. In addition, so even these photographs that we're talking about, so the photographs taken after obviously show that it's fixed, but if you look back at the 2018 photographs, plaintiff never saw them before the day of his deposition. Now he's looking at it at the day of his deposition, shown by his own counsel. Hey, I got these photos from 2018. Does this look like the defect? So that is a credibility issue for a jury.
Yeah, but you didn't counter that. I mean, he looked at the photograph. You're not disputing that they were made when made, and that they were and that they depict fairly and accurately what the plaintiff said under oath, that fairly and accurately reflects the defect that I tripped on, which he estimated to be 1.5 inches. There was nothing to counter that. And Tropper seemed to allow that type of evidence to be part of a prima facie case without precise measurements, unless you read that case differently.
The fact that there's not precise measurements is that there's different measurements that are here, right? We have a 1/2 inch, we have an inch, we have 1.5 inches. We don't really know what it was, and we don't know whether it was repaired at the time. And understand that I did not put in any, or was not put in any evidence that we actually repaired it, but there's sufficient enough of an issue of fact that we're deciding as a matter of law that this is a dangerous condition.
All right, thank you.
Thank you.
Good afternoon, Your Honors. I represent 1550 Realty and SN, and we also would like the summary judgment to be affirmed. And basically for 2 separate reasons. The first one is, like counsel just mentioned, there are issues of fact regarding the defect. There is a number of factors in order to determine whether a defect can be dangerous or not. And in this case, plaintiff only submitted.
Any evidence in opposition to plaintiff's motion for summary judgment?
I don't believe we did, Your
No,
Honor.
you didn't, right? You didn't put in an affidavit, you didn't put in any records, anything in opposition. So assuming that we found that it was a prima facie, you would agree that plaintiff should be granted summary judgment, except so I guess what I'm asking you is, what's your other argument?
So first of all, I think that I would agree with counsel, it's his burden to prove it. And he only submitted one
Right, so
characteristic
again,
of the
assuming that
defect,
we
and if
accept
he-
it, what's your other argument?
Who do you represent?
Who do you represent?
1550 Realty and SN.
But are you the owner of the site?
We are not owners.
So my understanding is the condo is the owner, and putting aside the lease between the 1550 and the tenant, putting in their mutual responsibilities there, the condo bylaws make it very clear that the condo's on the hook as the owner, correct?
Yes, that is correct.
So why are you here?
We were named as defendants in the suit, and our argument below is that we are not owners within the section 7 to 10. And also the bylaws make it clear that it is the WB condo responsibility, to maintain and repair common areas.
Including the sidewalk.
Yes, and so it is our argument that, even if they had made, the proper prima facie that the defect is dangerous, we're not the proper defendants because we do not owe a duty to the plaintiff. We are not owners, and therefore we don't owe a duty to them. So that would be our argument. Thank you.
So, counsel, I have to ask you, I know you're getting up, but did the plaintiff say that he fell after the repairs? Did he testify that he fell, he fell after the repairs?
No, he never said that.
Well, I mean, that's what counsel for the condo is saying, right?
Right.
That it was
Plaintiff never-
issue of fact as to whether he fell before or after the repairs were made.
Plaintiff never testified he fell after the repairs. I don't know where that's coming from. That was not in the record, certainly not in the briefs. It was never.
Enough to, it's even simpler than getting the contractor or whoever repaired it. You could even get the condo guy, the condo board saying, oh, we repaired that.
That's all it would have taken.
That's it.
All it would have taken. In that 2-year span, I'm sorry, that 1-year span from the last complaint by the tenant, we went out and we fixed it. Done.
From the last accident. from the last accident.
From the last accident, correct. In that year span, where is the all-area guy that's going to say, we went out there, we responded to those complaints, we fixed it. This plaintiff is lying. Okay, that's all they had to do. But they didn't do it. They said discovery, we need to do discovery.
And with respect to the photographs, the plaintiff testified that that was a good and accurate representation of what the sidewalk looked at the time he fell, right?
That's what my client said.
And he also independently testified, I fell on a big crack, right? So it's not, so even if they were hearsay, your motion's not based solely on hearsay.
Correct.
Right.
But that evidence was nonetheless authenticated from the affidavit of the tenant later when he said, these are the emails. And then in the photographs, my client said that is a fair and accurate. That's all authenticated
He
anyway.
testifies, just to take you back, he testifies that the repair was made a week after he fell, didn't he?
That's what he said, because he went back to
It had
take
been
photographs.
industrial sanded?
Sorry?
A week after the fall, that had been industrial?
Industrial sand, the way he described it, and then he took a photograph. That's all he could do. We wanted, every lawyer loves to get the picture of a defect. When it's repaired, we can only do what we can do. That being said, it's undisputed that the condominium has the non-delegable duty and that the property manager displaces their obligation. Now, as far as the unit owner, I understand the holding in Faioli that they're not considered the owner per se, but there may be some other obligations under the condominium document. That was the reasoning.
Like what? What are you raising? Is there anything, we're at the summary judgment stage. If you got something, you have to put it up.
I agree. Look, they didn't move though, but the condominium document do impose duties by virtue of the easement to do repairs. So there's an issue of fact, at least on their obligation.
Well, at the end, your argument may be a fight between them. You're looking at one thing. You want summary judgment in favor of your client, regardless of who it's against, right?
I mean, that would be wonderful. Thank you. Thank you.
We'll see. Thank you. Allen versus ZZ Construction.
Good afternoon. My name is Ben Kinsler. I represent the appellant defendants in this case. Your Honor, the plaintiff had filed no less than 3 separate complaints. And in June 2016, more than 6 years prior.
This went to a bench trial. This was finally tried before Judge Cohen, correct?
I'm sorry?
This case was
bench trial.
Was bench trial. I want to make sure I got the right appeal. Sorry. So it was tried as an unjust enrichment claim.
Correct.
So why? Your argument is that there's a contract in place.
Correct. Correct.
But that contract claim got dismissed on the 3211 a while ago.
The contract claim got dismissed. The cause of action for breach of contract got dismissed because the plaintiff's complaint failed to plead.
Okay. Correct.
But that doesn't serve to negate a defense of the existence of a contract in defense of an unjust enrichment claim.
Did you plead that? as a defense to the
I
unjust
don't know that you
enrichment?
have to plead it. I think,
Okay, assuming that I think you do.
Okay.
Because an unjust enrichment claim would be barred by a contract, right?
Okay.
Did you plead it?
no,
Did you argue it at trial?
no.
Okay.
However, the unjust enrichment claim was against the corporation. And what the court did in Justice Branston's 2016 decision had dismissed the fraud claim. The only claim is against the individual defendant, Zizzy, was the claim based on the piercing of the corporate veil. So if you found liability on the unjust enrichment claim against the corporation, you impose liability against Zizzy individually. However, the court expressly found that there was no basis for piercing the corporate veil. However, the court then reinstated the fraud claim that Justice Branston had dismissed in 2016 and proceeded to find officer and director liability on the grounds of fraud. So they reinstated a claim against Zizzy individually, which it wasn't in the pleadings, it wasn't before the court, and in fact, Justice Branston's decision in 2016, I suggest to you, constitutes law of the case and should have been dismissed, and the court had no right to reinstate it. It wasn't before the court. The other issue, of course, is the mid-trial assignments. The court took, the plaintiff waits more than 6 years, knows that the issue of his standing is an issue before the court. He waits 6 years and waits until the second day of trial to come in. There was never an attempt in 6 years to have the LLCs intervene in the case. There was never an effort in 6 years to assign the claims from the LLCs.
Well, I gather you made a motion to dismiss based on standing then, right? If you make
Correct.
it okay. And
Yeah, it was timely raised.
it was not timely raised, but when you made them, did you make a motion to dismiss so that they could have corrected it earlier? I mean, this is a situation where they ultimately corrected the standing issue.
I'm not following, I'm sorry.
So you're making the argument that they didn't have standing, right?
Correct.
Correct?
And that was in the motion. It was a timely motion.
What motion was that?
It was a motion made in April of 2016. The plaintiff filed a number of complaints. There were stipulations.
You made a motion based on standing in
Yes, in fact-
2016,
in
and what
fact,
happened to that motion?
I'm sorry?
What happened? What was the decision on that
The
motion?
judge, basically, she didn't decide the standing issue, but she acknowledges the
Did
standing.
you ever appeal it?
No.
So if it wasn't if it wasn't granted, right, it
Right.
was denied.
Okay,
And no appeal.
okay.
So the first time you raised standing again after not appealing the denial of the motion was at the trial?
Well, we raised it, it was raised in.
Did you make a motion to re-argue, motion to renew, motion for clarification, anything that would have given the plaintiff an opportunity to correct what is an easily correctable issue?
The plaintiff knew
I'm
the
asking,
standing.
I know, but I'm asking about you, whether you made
We did.
any.
I was not the attorney.
That's a
No,
problem,
but
right?
I'm punting, but yeah.
No, of course, but I'm just asking you, did anyone make that motion?
No, they
Because
didn't.
it's clearly
They didn't.
correctable if somebody raises it, right?
Correct.
Okay.
Okay. But again, you still have the issue of, where was the defendant the plaintiff for more than 6 years? And certainly to prosecute a claim, you have to have the right to prosecute that claim, and the claim wasn't his. And he claims the complaint is replete with allegation after allegation that I made the payment, that I had the contract, and the evidence establishes otherwise. The evidence and the documents and evidence clearly show that the claim belonged to LLCs and not to the plaintiff. And to correct that, he comes in on day 2 of trial, and to the surprise, and we turned down the settlement offer on the basis of our defense. And frankly, had that defense been a viable one, had they addressed it, we probably would have settled and saved the defendant a significant amount of money. So,
Thank you.
thank you.
May it please the court, good afternoon. Michael Cassell for the plaintiff respondent Jeffrey Allen. The crux of the claim here is an unjust enrichment claim. It's a claim where the...
May I ask you to address counsel's argument that there should not be pass-through to the individual defendant because the claim was against the corporation?
The unjust enrichment claim, I was just looking at that, Your Honor. It's page 81 of the record, which is the complaint, the operative complaint. It says against defendants, so I don't
All
even...
the defendants,
Just
including,
uses-
yes.
It says,
And in fact, Mr. Zizzi pled to taking some of that money, right?
Yeah, not only that, Your Honor, the
So
criminal
he admitted that he was unjustly enriched by some of the money that your client paid,
was,
right?
and plus the criminal action was actually filed against Zizzy individually and Zizzy's companies. Zizzy's companies were dismissed from the criminal action. Zizzy individually acknowledged and pled guilty to stealing my client's monies. I submit there's really no clearer case of unjust enrichment in a situation where the defendant pleads guilty criminally to stealing my client's monies, goes to jail for 8 months. That is against equity and good conscience to permit. I mean, really, we have the monies here. The question is, who gets to keep the monies? You know, should it stay with my client or a convicted criminal, Mr. Zizzy, who admitted to stealing the money?
How do you answer your friend's point that Mr. Allen isn't the proper bearer of this suit, that he didn't have standing?
There's multiple responses to that. First, I'll just address procedurally, because I think the court hit the nail on the head. So defendants move for standing as part of the motion to dismiss. Denied. Defendants do absolutely nothing. They don't raise the issue. They don't try to move, attain summary judgment on the standing. The trial starts with Mr. Kinsler, and I handle the trial also, and they try to convince the court there's a standing argument. So, to me, that would be basically amending the answer, because there's no standing in the answer. They've waived it.
In your view, standing is an affirmative defense. It's not a precondition to the plaintiff seeking relief.
Right, it's an affirmative defense, but even if it's not, the court, Justice Cohen aptly cited the case, the Court of Appeals case, Han Fui, I believe it is, and also we have the resolutions, but also...
So it's your position that because the motion was denied before, that you had a good faith basis for your believing that you were not going to be challenged on standing, and then when it became clear, you fixed it?
That is pretty much...
Okay.
I mean, not only did we fix it, that's 100% accurate.
But you cured it's a curable issue. I mean,
Right.
from what I've read from Judge Cohen's decision, it got cured. Whatever is standing issue got taken care of, right? It's not a jurisdictional issue that we're talking about. It's a pleading issue, right?
Correct. We took care of it. And plus, also just to keep in mind, the companies only exist for monies that are put into it. These aren't operating companies. It's an investment into basically buildings. It's Mr. Allen's own monies. Mr. Allen, litigated the case since 2015. This is all addressed to Justice Cohen. He analyzed the issues and properly found in our favor on it, and it should be affirmed his decision. Any other questions? Thank you for your time.
Thank you.
I respectfully submit that if the LLCs were being sued, my adversary would probably argue very vociferously that they have separate identities.
So, counsel, do you agree with your adversary that the unjust enrichment claim was pled against Mr. Zizzi individually?
No, I don't. No, and Mr. Zizzi did not acknowledge that he was unjustly enriched.
No. I'm just saying, as a matter of pleading, did they plead? Did the plaintiff plead the claim against him?
The pleadings are respectfully not clear. They asserted it against all the defendants,
Right.
but it's not clear.
I mean, he is a defendant, right?
Well, except that the trial court made findings. The trial court didn't have to go on to the issue of finding liability against Zizzi individually based upon the officer and director liability for fraud, if in fact they would have found liability against him on the unjust enrichment claim. So in doing that, I think implicit in the court's decision is the very fact that the court didn't find Zizzi personally liable on the unjust enrichment claim.
Okay. Thank you. Thank you.
Thank you.
U.S. Bank versus Tabinia.
Good afternoon, Your Honors. May it please the Court, Anthony Filosa for Appellant, the Domain LLC. The judgment of the Supreme Court should be reversed purely as a matter of stare decisis. I mean, this case is on all fours with this Court's precedent of MTGLQ Investors v. Shea, 190-80 3D 527, where this Court held that a non-party to a foreclosure action, who is a judicial sale purchaser, who is the current owner of the mortgage premises, has standing as an interested person under CPLR 5015A to move to vacate a default order
How do you have as non-party, where personal jurisdiction is personal to the individual, how do you have a right to make that argument on their behalf?
Sure, there are two independent bases. 5015A says an interested person, not a party, may move to vacate a judgment or order on any of the following enumerated grounds. One of those enumerated grounds is A4, lack of jurisdiction. So as a matter of statutory construction, the fact that the legislature used the term interested person in 5015, let's hold that up, a mirror up to that to say 3211 or 3212, a statute which also authorizes the making of a motion. Those statutes use the term party. So by definition, there has to be a distinction between party and interested person.
No, but yes, but when they're talking about that, they're talking about jurisdiction, but they're not talking about service. Service is personal. There's no way that your client could ever know or not know or have any information about whether service was good. So you can't assert it. And there are lots of cases that say that a third party can't assert improper service, which is what your motion was based on.
Right, but our motion is brought under 5015A4, which seeks to vacate a default judgment. And again,
on the basis of improper service,
Correct.
which is not something that's is a defense that's personal to the person served. And I can cite you 25 cases that say that. You were not the person served, you were the assignee. So you can't assert that.
we can because it's our property interest that's being affected by the default judgment.
Except, yes, but you can't assert that defense.
Well, that's the defense we asserted in Shea, and then that's why this case is on all fours with Shea. Shea, again, the judicial sale purchaser moved to vacate for lack of personal jurisdiction over the borrower Meldow. I'm quoting, "The order should be vacated because the motion court lacked jurisdiction over Meldow in entering it. The motion there was made by a judicial sale purchaser who is a non-party to the foreclosure action." And again, we cite numerous examples under 5015A4 and 1018. I think 1018 is a separate basis. We essentially stand in the shoes of the borrower. So if the borrower could raise that defense.
The case you're reciting to is Shea?
Correct.
What's that site?
190 AD 3D 527. It's a 2021 case decided by this court.
Say again, 190 AD 3D.
190 AD 3D 527.
All right. So, okay, so anyway, you asserted that, but in any event, your purchase is subject to the mortgage. So what's the problem here?
Correct. I think the fact that a purchaser takes subject to a mortgage doesn't stop the purchaser from contesting the foreclosure action. Again, that's Shea.
Okay, but you have to be bound by all the proceedings that happen, and you are bound by the foreclosure. That's it. You're bound by it.
Right, but the fact that there's a notice of pendency also the Shea court recognized didn't preclude us from moving under 5015A4.
It doesn't matter. You are bound. That is straight up. You cannot just avoid the fact that the foreclosure happened. You were wiped out by it.
Well, they were, again, so the Shea purchaser purchased, and the Shea decision recognized that at the time of the purchase there was a notice of pendency. We still weren't precluded from moving under 5015A. And again, the fact that
that doesn't change the fact that you don't get any relief because you were subject to you were bound by the foreclosure action.
Well, again, but I still think that the presence of a notice of pendency, one, that just begs the question, because a notice of pendency is not valid if there's no personal jurisdiction, right? CPLR 6512 says that in order for a notice of pendency to be valid, the summons has to be served within 30 days thereof.
6501 says, a person whose conveyance is recorded after the filing of a notice of pendency, which is you, is bound by the proceedings taking in the action subsequent to the filing of the same, right?
Right.
So you got after the foreclosure, you got the assignment, and you're bound.
2 points. Again, the Shea purchaser took subject to a notice of pendency. 6512 says that a notice of pendency is not valid if a summons hasn't been served within 30 days. So again, this all begs the question. If the service wasn't proper, the notice of pendency wasn't proper, an improper notice of pendency doesn't impart notice to a prospective purchaser. And on the larger estoppel issue, again, we cite this Court of Appeals case at page 18 of our reply brief, McCracken, 141 NY 174. quote, "It may be true that the plaintiff took his title to the land with notice of the claim, but that notice does not operate as an estoppel as against him. He had a right to take conveyance of the land, and he thereby obtained good title to it." So again, the fact that we purchased while there was a mortgage pending, while there was a notice of penancy pending, doesn't stop us from contesting the validity of jurisdiction.
Thank you.
Thank you.
May it please the court, James Fowler of Reed Smith on behalf of the respondent, U.S. Bank. I want to start by addressing a couple of the cases that were cited by appellant's counsel.
You relies primarily on Shea.
Well, in Shea, Your Honor, the actual basis of dismissal was for a 3215C violation, which is failure to move for default judgment within a year. And I believe that was applicable against both defendants. Anything beyond that was mere dicta that would fly in the face.
Yeah, I'm reading it right now. It says, therefore, 21647 could probably move to vacate the default on a legally recognized basis, citing 5015A. So as my colleague, Justice Garpool, is saying, it's got to be legalized, recognized basis. I mean, just because it's listed doesn't mean it's legally recognized that you have it, because as she makes a valid point, how are you on God's earth going to be challenging service of process when you're not the person being served?
That's correct.
Where's the legally recognized basis for that?
That's
It didn't say you can move by 5015A, and that was it, without clarifying exactly what we were saying. So Shea is kind of not exactly on all fours.
Exactly.
Love these babies, I got to tell you.
And Your Honor, you're making the point for me, and I would like to quit while I'm ahead on at least Shea. In terms of McCracken, which is the case.
Oh, what's the cite to that one?
I forget the exact citation.
We'll figure it out. We got it.
That's a case from 1884. And,
okay,
and one of
it won't go that far, these
and,
things.
And one of the important words that was not included in what was recited there was that the judgment itself at the time was void, okay? This title was taken subject to a very active notice of pendency. It was not void or avoidable. Now, CPLR 6512, which gets to notices of pendency, does not require service of the notice of pendency and summons within 30 days upon the owner of the property or a single necessary party. It's any defendant. There are multiple defendants in this case, none of whom are challenging service beyond.
No, I agree. I think the law is that unlike a 3215, it's clear from the record whether someone brings the motion within a year, and anyone can, right? That's a completely different thing than saying I wasn't served, which is there are plenty of cases that say is a personal defense that can't be raised by a third party.
Exactly. So even arguendo, say we threw out Tabibnia here, you still have notices of pendency that were valid against all of the other defendants. This deed was taken, at this condo board's foreclosure sale, subject to those notices of pendency. Very important here. For over a century, courts have held that foreclosures are in rem actions.
Let me just ask you something. Did the movant make a motion to intervene?
No, they did not here. They did not move to.
What do you think about that?
I think that the appellant is coming to this court looking, citing to equity, but looking for an inequitable result. You can't just show up and use someone who's
in a case that you're not named as a party.
Not named as a party, and use someone as a sock puppet.
Probably almost certainly know that the mortgage is in default.
They would certainly, the mortgage is of record, the notice of pendency is of record. They can find these documents. These are publicly available. They know it's in default. There's really no question here that they took this title with knowledge of this foreclosure, with knowledge even of this order of reference. To argue otherwise is really in bad faith. I mean, if you wanted me to get into the actual service, I'm happy to do.
On this record, basically, Domain was not able to rebut the presumption of proper service in New Jersey, correct?
That's correct. That's correct. I mean, our process server tried 3 different addresses in New York. I mean, that's well documented. They served him in New Jersey. An apparent relative,
who acknowledged that was the place of residence.
Acknowledged that it was their dwelling, accepted service. The appellant makes a big deal of, I can't find this process server registered in New York. Of course you can't, because this was served in New Jersey. I think I've hit all the points that I can here that really make any sense. So unless the court has any further questions, I'll rest on the papers.
Thank you.
Thank you.
Thank you, Your Honors.
Well, you know, Shea doesn't say exactly what it says. It's legally recognized basis, and then it cites 5015A.
Right, but this
To me suggests that you can have all the ones that you listed, but only if it's legally recognized. And as my Justice Garpula pointed out, when it comes to service, case law out there says it's a personal nature.
I'll quote the remainder of the Shea decision. Dismissal of the action as against Meldow is appropriate for the independent reason that she was never properly served and personal jurisdiction was thus never obtained over her.
Right, but that's Meldow. That's not the.
No, but Meldow wasn't the move-in. Again, the judicial sale purchaser was the move-in. Meldow did not
But
move.
it was interesting enough, well, you know, I'm not going to argue with it. But the bottom line is the court didn't say based on whatever, allowing 21 whatever to make that argument on behalf of her. I don't know.
That was a 3215 motion for failure to enter the judgment within the year, which is clear from the record and wouldn't require the kind what you're asking us to do as someone who's a stranger to the service and has no idea what happened.
The alternative grounds was also a 306B motion, but I also just want to identify there are other cases emanating from this court where a non-party whose property interest stands to be affected by a default judgment may move to vacate a
Yes, did you move to intervene in the action?
No,
Why not?
because intervention, again, is not required because we're an interested
It,
person.
what case says that you don't have to actually move to intervene?
Right. I'm quoting Shea. Judicial sale purchasers, this is this court's words, judicial sale purchasers' title and status as the owner of the equity of redemption made it an interested party and gave it standing to oppose the plaintiff's foreclosure action.
That has nothing to do with whether you have to make, yes, you have standing, but don't you have to make a motion to intervene in an action in which you are not a party?
No, because again, for two independent reasons. Again, under 1018, we stand in the shoes as the owner whose equity stands to be foreclosed by the judgment. Under 1018, the action can continue as against us. We can defend in the name of the named defendant.
Without moving to intervene, without anybody deciding whether or not you actually do have standing?
Well, because our deed is a matter of public record. Our interest, the irony here is the borrower, once they make a conveyance, they're no longer a necessary party. So to hold that we don't have standing would mean no one has standing.
I'm sorry, you said something interesting. I don't mean to cut you off. That the domain was recorded. I thought the bank was recorded. I don't remember that your deed was recorded. I don't believe it was.
The deed was delivered to.
No, you're not, was it recorded? New York is a recording state.
Correct.
On this record, I do not believe that deed was recorded. Was it? Yes or no?
The deed was recorded after the filing of our motion, but the filing of a deed the recording of a deed is not essential to convey title. A deed conveys title upon delivery, upon the date of the deed. That's not essential to convey title. Obviously, recording is in everyone's best interest, and the deed was in fact recorded here. But I guess we moved, we took title, we moved, the deed was recorded.
Okay, thank you. O'Connor versus CVO Advisors. I mean, O'Connor versus Society Pass, I'm sorry. Okay, you're up.
Good afternoon. May it please the court, Michael Knack for the Defendant Appellant Society Pass. What is at issue here is ultimately whether two instruments should have been integrated.
Right, the warrants versus the employment agreement, right?
Yes.
Your argument is they're integrated, so that he wasn't entitled to the shares, the 1,148 shares that the court believed he was, right?
Yes, but more basic than that, we believe also that part of his prima facie case to gain entitlement to summary judgment was to establish his performance under the integrated agreement, which he did not do.
KPIs, right?
And not just the KPIs. The KPIs was certainly part of it, but in general.
What in the warrant says that?
I'm sorry?
What in the warrant says that?
So the warrant it does not specifically say that he has to comply with the employment agreement.
How does it non-specifically say it?
So the employment agreement was annexed to the warrant. They affect the same purpose. They are inextricably intertwined.
You annex an agreement to the warrant without saying anything in the warrant which says that they're integrated or that you have to comply with the agreement, and you mean to say that that incorporates into the warrant what the contract says?
Well, yes,
I
and
mean, why are you sending him the warrant? Because your agreement called for there to be an agreement upon KPIs which were never came to fruition. Did you ever present proposed KPIs to the plaintiff?
so there's a dispute about that. We contend that we did and that the plaintiff did not accept them, and the plaintiff contends.
But in any event, fine. You never agreed on KPIs. Why are you sending him the warrant?
I don't know the answer to that, Your Honor, but I think the more pressing issue, what's more determinative here, is whether these two documents are integrated such that the
But as my colleague was pointing out, you sent him the warrant, which is a superseding document. It's something in writing that theoretically could be interpreted as a modification, which the original employment agreement provides for, that a modification can only be in writing, and the warrant was in writing. It was signed by the president and Mr. O'Connor at the end, and you actually gave him, among the number of shares, you gave him 861 shares, and it was a warrant where the shares were given for value received. And there's no mention of the KPI or any kind of condition, unlike the agreement, that has a whole separate trajectory for how to get shares in the agreement. So why can't it be a standalone document?
Because well, first of all, the issue of whether it's integrated is an issue of fact, and the annexation of the two documents as a matter of law is sufficient to raise an issue of fact. Further,
Wait a second. You're saying just because I hand someone two documents that don't say anything about each other, that raises an issue of fact?
well, I'm not saying that alone. I'm saying that that in connection with the fact that they effectuate the same transaction.
No. The employment agreement effectuates employment. The warrants effectuate payment.
But
They're completely different things.
the agreement does speak to these warrant shares, and the warrant agreement does reference the employment agreement, and this is the precise scenario that was
Besides the fact, didn't the Singapore subscription indicate that the plaintiff had been given shares?
I'm sorry, I couldn't.
Didn't the Singapore Fund subscription agreement indicate that the plaintiff had been given shares?
So there are two issues with that. The first is that those were indicative shares that was meant to indicate to potential investors what its potential dilution might be. The other issue is that if that argument.
Let me just ask you, that's your statement, right? You made that, your client made that statement.
The Fund Singapore?
Yeah. Yes. So, and now you're saying, yeah, but we didn't really mean it?
Well, it's not that they didn't mean it. It indicated the potential.
I understand what it, but it said he had these warrants,
And-
right?
Yes.
Straight up.
He had the warrants,
Right.
not that he was entitled to the shares.
Well, if you have the warrants, right, and he exercises them, how is that, and you acknowledge that he has them and he exercised them, right?
Well, he can only exercise them if he's entitled to. And to go back to the point, he has to.
And didn't you say in that document he was entitled to these warrants?
He was not entitled to exercise the warrants. And just to address a certain point here, if indeed that document says that he has those 861 shares, then that, we do argue that he wasn't entitled to them. But if that says that he had those shares, then he has the shares, and we're not talking about failure to issue shares. We're talking about what are the damages for not having stock certificates, which is a completely different measure of damages than I think is being issued. Is at issue.
Well, he wants to know, I mean, but, right, isn't there going to be a hearing on what the damages are?
Well, there's a difference. So if the company was refusing to issue shares, then his damages are, this is what the shares are worth. If the actual issue is he has these shares, but he just didn't get the stock certificate, then the measure of damages is.
Did you argue that below?
I'm sorry?
Did you argue that below?
I don't recall.
I didn't see anything about that below. So do you think you made that argument?
I mean, if I don't recall, but right. I trust your.
Good afternoon, Your Honors. My name is Ethan Brescher on behalf of Respondent.
You've abandoned the damages issue. You put in a notice of course appeal, but you haven't made any argument about it. So the issue of damages is not really before this court. Am I correct?
That's right. And actually, next week, we're having a hearing before a special referee on the damages. Justice Cohen ordered
So
that.
damage is just not an issue here today.
No. I mean, the answer is it's not an issue here today.
So the main issue is, they're arguing that these two documents are integrated. It's a single document. Your position is they're standalone, independent of each other. They operate, just reading the language of the warrants, there's nothing in there that hooks in the employment agreement.
That's correct, Your Honor. It doesn't incorporate it. It doesn't reference it. The warrant simply says, as an appendix, there was an employment agreement, and that's all. I think Your Honor was in the Huang versus Mire case, and Your Honor was the trial court judge in the Huang versus Mire case, where you said there was a replacement contract, and this warrant replaced the terms of the employment agreement, which the KPIs, which they rely heavily on, are mentioned nowhere in the warrant. The warrant is also...
There's a fellow employee of the plaintiff who also received warrants. Isn't that so?
That's correct. The Narain versus Society Pass case with Justice Bork granted summary judgment in favor of the employee.
Does the record reflect what his contractual position was? I mean, was there an employment contract with him, which is the same as the one with plaintiff?
He did. He had a contract that also had this KPI potential provision. The only difference is that the warrant in that case didn't attach the employment agreement as an appendix, but that was the only difference. Here, there's no reference in the employment agreement.
I mean, I'm looking at both documents, and I'm not finding, well, the employment agreement happened a year earlier, so it wouldn't be, you couldn't say that there's, we're talking about a document that hadn't been thought about. But clearly, the warrants document came out about a year later, almost a year later.
It was not even a year, because the employment agreement was from, I think it was November of 2018. The warrant agreement is from January 2019. It was a few months later. They could have easily, and it was drafted by their lawyers. They could have easily included the language. I'd also point your honors out to the case that I added as a new authority from this morning from this court called Catamine Metals against Macquarie, which talks about, because one of the arguments they've made was lack of consideration, and we relied on General Obligations Law 5-1103. I think two of the judges on this panel were also on the panel in the Catamine case. One of their arguments in their brief was lack of consideration for the warrant, and
Well, doesn't the warrant say for value received?
it absolutely does, Your Honor.
So isn't that enough to show consideration?
We believe so, but they say that that's not enough. So
Well, why would you put in for value received if you didn't get any value? Why would anyone put that in a contract if they didn't think that there was consideration?
well, I think their
Shouldn't we
lawyers.
assume that people mean what they say?
I think their lawyers did a great job at drafting the warrant. If there were no other questions.
Thank you, Your Honors. I just wanted to...
I really don't know how you go to this integration argument when you look at the first page of the warrant, as it appears on page 91 of the record, which states, this certifies that for value received, Thomas O'Connor, the holder, is entitled upon the terms and subject to conditions hereinafter set forth. It's making it dependent upon the conditions which appear in the warrant, and there's nothing about KPIs in the warrant.
I think what I'm trying to distinguish between is the requirement to fulfill KPIs and the requirement to establish his performance under the employment agreement. Section B of the employment agreement says that as consideration for your employment, you're getting these warrant shares, and then the warrant is later on. Yes, it is later on, but
Did he get the warrants when he was employed?
he received the actual form of the
So
warrant.
he was employed and he got the warrants. What is your argument that he didn't do?
So the argument is that he did not successfully perform his job. He didn't do what he was supposed to do. And the warrant was supposed to be kind of a
If that was true, why did you send him the warrant?
because it was supposed to be vesting over periods so that if He did do his job. He could submit a notice of exercise.
And the warrant has a vesting, right?
Right.
And did the warrant vest while he was employed?
The term of time did vest, but he did not do what he was supposed to do.
I don't understand. He's employed. The warrant says you get it if you're employed this time, right? It doesn't say only if we like you or only if we think you're doing well. It says if you're in our employ, then you get this warrant. Then he gets the warrant, which says something different. And it says you're employed for value received, you got this, which I assume is the employment. What is the question of fact?
The question of fact is whether he established that he performed under the employment agreement. Again, the warrants are consideration for the employment agreement. So they,
Given the level of sophistication of the parties, shouldn't we expect that they would make reference in the warrant to any condition to the receipt of the shares, or at least incorporate by reference the employment agreement?
well, I think the warrant did reference the employment agreement. The employment agreement does reference the warrant shares, and I think...
Well, they made reference to one another, but they didn't. If the parties wanted to incorporate the terms of the employment agreement into the warrant, wouldn't that have been an easy matter to just make that plain?
Well, that's what they were doing by attaching it instead of rewriting the entire employment agreement. The warrant...
It's so hard to accept this because when you look at page 85 of the record, 3B of the employment agreement, so what it says is both the company and the executive shall draft a list of mutually agreeable key performance indicators by December 31st, 2019, which governs the issuance of shares. And the list of KPIs shall be treated as an addendum to this agreement. So this was expected to have happened by December 31st, 2019. It doesn't happen, and yet you go out and send him the warrant on January 31st, 2019. It just looks like you just decided to forget about this all of these conditions or anything like that and just give him the warrants.
I understand, but if I may conclude on a particular point that I've been trying to make, is that these two documents do affect the same purpose. It's payment under the employment agreement, and this was met precisely in Torvec. The plaintiff's obligation to get summary judgment was to make a prima facie case for breach of an integrated agreement. These two documents serve the same purpose. It's the same transaction, and all he did was allege that he sent the exercise price.
Is it that he complied with an integrated agreement, or to show that there's a warrant which entitled him to shares?
I think it's to show that he...
Your defense is that there's an integrated agreement, but doesn't he make out a prima facie case by saying, look, you sent me this warrant, I'm entitled to the shares?
Not when the warrant is integrated with the employment agreement. And again, this is precisely what Torvec meant, that when you don't perform under the service contract, the warrant, which is compensation thereunder...
You're raising terms that just don't, I just don't see it, but I hear your arguments. Okay, thank you.
Thank you, Your Honors.
People versus Paris Roberts.
Good afternoon. Sam Claflin of the Legal Aid Society for Paris Roberts. The court should adjudicate Paris a youthful offender. There are many reasons why. I'll focus on just a few today. First, the probation department recommended in the pre-sentence report that Paris be a YO. This court has long considered PSR recommendations in YO cases.
Yeah, but in my notes here indicate that the defendant here wasn't cooperating despite having all the opportunities, and that I think the people at one point just asked the court to revoke the defendant's YO opportunity because of the documented problems they were having with the defendant. So why is that an abuse of discretion in that regard for us to even, tap into our interests as justice powers and overrule the court below? I mean, it's not so much that the court didn't want to do it. It was just like the people finally said, look, enough is enough. He's not cooperating.
So first, as to the standard of review, just so we're clear, so this court can adjudicate a defendant OIO under the interest of justice.
I'm not disputing that. I'm agreeing with you. Yeah, but why should we find that the Supreme Court below abused its discretion, given the record that the court had before it? I mean,
well, Your Honor, an abuse of discretion is not required. That's my point about the standard of review. In the interest of
knock that out. In the interest of justice, why should we do something then?
Yeah, certainly. So, I was speaking to the pre-sentence report recommendation. As to the failure to comply with the plea conditions, so, we had the new charges at the time of the YO consideration. And as to those, the record reflects that the factually violent gun charges were dismissed. The surviving counts were for mere possession. Paris was not apprehended with a gun.
Mere possession of a gun?
I'm sorry?
Did you say mere possession of what?
A gun. That was, so the surviving counts were for mere possession of a gun. Yes, Your Honor.
Does mere and possession of a gun go together?
He was in possession of a gun. The point is that the factually violent counts were dismissed. He was not apprehended with the gun. The record reflects that the evidence linking him to the gun was weak, and that case was set for trial.
Isn't what happened here, the court adjourns this for sentencing to see whether the defendant can earn, if you will, YO treatment. Is that correct?
Yes, Your Honor.
And he's sent to cases, and he misses a lot of cases appointments, right?
That's right.
And while this is going on, he improves his cases appointment, appearing for cases appointments, but then he's got 2 other arrests.
Yes. So I was just speaking to, where the case stood as to the gun arrest. And again, for a litany of reasons that the record reflects.
So how does that get him to earning YO treatment? I mean, the court was really trying very hard to give the defendant YO treatment, but it's sort of like every step of the way, he was telling the court that he hasn't really earned it.
As to the new charges, again, they were just charges at this time, and I just spoke to the reasons why those should not preclude YO adjudication here. As to the case's involvement, so it's important to acknowledge that, as Your Honor noted, his participation did improve over time in the case's program. Further, he had been voluntarily engaged in the Getting Out, Staying Out program since even before this case had begun, so he had got the benefit of a program in this case. He participated in that program and prioritized it because he had an established rapport with his longtime social worker there, and he found it more manageable. Regardless, go ahead.
Sir, I mean, in your own reply here, you basically acknowledge that his failure to fulfill the plea agreement weighs against YO status. You said it on page 4 of your reply. So as my colleague pointed out, in addition to poor attendance at Casey's and positive drug tests and the 2 rearrests on very serious charges, that whole mix together doesn't strike me as being a record where this judge would be found to have abused his discretion denying YO status.
So again, abuse of discretion is not required, Your Honor, and then indeed, those are the factors that weigh against YO treatment here. We concede those, but there are many factors weighing in favor of YO treatment here. Again, the PSR, the probation department recommended YO treatment in the PSR. Paris did have the program involvement through the Getting Out, Staying Out program. And also this offense arose in the context of his untreated drug issues. His father before him struggled with drug use and left the family. And when Paris's brother, who became his father figure, just died just 2 years before this offense, Paris tried numbing himself with drugs to cope, and that spiraled out of control and led to the instant offense.
But the court below, you gotta concede that the record here, the court did not do this as like a knee-jerk reaction. It really went out of its way to try to avoid a situation where it was not going to adjudicate him a YO. I mean, it was, it even warned him. I mean, it says, at one point where they said, well, they wanted to revoke it, the court revoked the YO the designation. The court adjourned the case again and warned the defendant, you got to keep it straight. And then he goes and gets arrested he gets charged for weapons possession in federal custody, facing weapons charges. I mean.
So just briefly, I agree that this was not a knee-jerk reaction. There was careful consideration here, but that doesn't mean that the sentencing court got it right. And again, this court can substitute its discretion for that of the sentencing court.
The question is, why should we?
Yes, and I believe I've already spoken to that, and I continue to do so on.
Okay, thank you.
Good afternoon, Your Honors. Jamie Matson for the people. To answer the Justice's question here, there is no reason why this court should substitute its judgment for the sentencing court. As this court already seems to appreciate, it's the defendant's own actions and choices that show that he squandered the generous opportunity given to him by the court to earn youthful offender treatment.
Counsel, how do you respond to the PSR report recommending YO status?
Sure, certainly. So as to the PSR recommendation, we don't dispute that in one part of the PSR, next to the words YO recommended, the word yes is printed. We don't dispute.
The word, I'm sorry?
The word yes is printed. We certainly don't dispute that. But that recommendation seems to be entirely at odds with the other parts of the PSR. So specifically, in their assessment of the defendant, they write that defendant, quote, clearly demonstrated a propensity for violence, that he, quote, appears to be a threat to community safety, and, quote, is in need of a restrictive setting. So it's not entirely the glowing endorsement for youthful offender that my adversary
When was
makes it
that
out to be.
PSR prepared in terms of the denial of the YO treatment?
It was received to the court on July 2nd, 2019. And I'm sorry, I didn't hear the end of your question.
When was that PSR report prepared in terms of the sentence that was ultimately imposed? It was close to the time of the sentence, right?
So it looks to me that it was prepared.
But let me put the question a different way. What does the PSR have to say about the two other arrests?
They note the docket numbers and the federal case numbers for each of the cases, and that they are pending at the time. But a lot of what we know about those two charges actually came from the people. So the people put on the record, and the sentencing court were certainly made aware that in the Bronx for the attempted murder charge, the defendant shot at someone twice, quote unquote, miraculously missing each time. Now it's true the defense counsel below put on the record and represented that the attempted murder charge, not the entire case, just that charge had been dismissed, but it's not entirely clear that that's what happened.
And at the end of the day, did he plead to those charges, or was he convicted of them?
Well, before the sentencing court, the people countered that they did not share that information. Of course, they were pending at the time of sentencing.
Right now, we're asked to be using our interest of justice power, so it's curious to me as to what happened to those charges.
Ultimately, he pled to a criminal possession of a weapons charge in the second degree for a loaded firearm.
Okay.
That information, of course, was not before the sentencing.
No,
court.
no, I know.
That's what the attempted murder ended up.
That is correct, yes. Now, but even if we took all of that aside, the defendant was still indicted for an entirely separate charge, an entirely separate offense, a narcotics conspiracy charge, which was so serious it carried a minimum sentence of 10 years. The final rebuttal point I'd just like to touch upon is this idea of what is or is not on the record. Everything that happened between plea and sentencing, all of the numerous warnings, all of the defendant's poor compliance in cases, his then two pending indictments, the numerous times that people put on the record the very serious nature of the facts of this case and the facts of the case which are laid out in the PSR, all of that's wholly within the record. And that is enough for this court.
And in fact, the people had asked for that to come off the table, and the court actually gave him more time, right?
Absolutely. Numerous times, in fact, that cycle happened because the first compliance occurred on February 14th, 2018. The defendant did not appear because he was hospitalized, but the people put on the record that he had missed 6 out of 16 appointments with his case's representative. And it was at that point they first started asking for the opportunity to earn YO to be revoked. But the court said, no, look, the defendant is not here. Let's give him more time. So they returned on February 28th. And that report from cases said that the defendant had declining engagement. The people, again, repeated that they wanted the opportunity to earn YO to be revoked. They put on the record the facts of this case. The court gave him another opportunity with its strongest warning yet, that he had to show improvement and that any more poor reports could result in the court rescinding the offer of YO. And then by the time we get to the next adjournment, that's when he gets the 2 new indictments. So the totality of this record here before the court really emphasizes that there is no reason why this court should replace the discretion of the sentencing court below. Unless there are any further questions, we rest in our brief. Thank you.
Thank you.
I think it bears repeating that there were only pending charges at the time of the YO consideration below, and that the case dispositions there are outside the record here.
Right, but you're not arguing that the court below abused its discretion, right?
That's correct, because I don't need to argue
Okay,
that.
at that time it was. Now you're asking us to use our interest of justice discretion, which is a different thing.
That's right, Your Honor.
Right.
And this court is empowered to do that, and the Court of Appeals made that clear in Anthony C., and this court has in
Well,
fact done so.
I'm not disputing that. The question is now, since then, he pled to a gun charge, right? And you're asking us to use our interest of justice discretion to adjudicate him a YO?
We are asking this court to use its interest of justice jurisdiction to adjudicate him a YO, but Your Honor, that doesn't bear on what is and is not in the record in this case, and those case dispositions are not in the record. So I think as to the PSR, again, the YO recommendation there is clear. I think it's significant.
Well, does it, the PSR say he's a significant, that there are other things in the PSR that would undermine the recommendation, correct?
I think it's significant that probation acknowledged those very struggles and nonetheless recommended a YO. I think that's particularly significant here and weighs in favor of YO. And this court and the other departments have numerous times granted YO based on the PSR recommendations.
Even though even the PSR says he has demonstrated a high propensity for violence.
It does say that. Again, I think it's significant that the probation department nonetheless recommended YO in spite of that. As to the program participation, again, he had been voluntarily involved with another program since even before this case, and I think that offsets his struggles with the court-mandated program here. So he was getting the benefit of a program. He had an established rapport with the other program. And regardless, the appellate division has recognized that someone can be a YO even with incomplete participation in a court-mandated program. They did that in Marcel G. and also the Darius B. and Charles S. cases we cite. Thank you so much for your time. We ask you to adjudicate Paris a YO or, at a minimum, vacate the surcharges and fees on the prosecution's consent.
Thank you. Fleischer versus John.
Good afternoon. May it please the court. I'm Georgette Fleischer. I am plaintiff appellant pro se. I think it's clear from my papers that my position is that this is not a garden variety medical malpractice case, but rather a case of reproductive negligence and fertility fraud, which contains elements of medical malpractice. My opponents in the court below have sought to subsume everything under the umbrella of medical malpractice. And I think that that is very much counter to the facts in the case and very much counter to case law. If we look at case law broadly, this is a relatively new niche in legal practice. And for that reason, I am going to make reference to a set of cases from the state of California that have a lot of resonance with my case. Actually, first a case from the state of New York, Del Zio v. Presbyterian Hospital from the Southern District of New York in 1978, before going on to Prado Morrison v. Doe from the 4th District Court of Appeal in California from 2008. And though it's not included in my papers, I'd like to wing in a related case from that same district, Stone v. Regents of University of California, 77 Cal, C-A-L, APP period 4th 736, because that case is more explicit about the elements that I share with this set of cases. So these are cases that came from the University of California Irvine Medical Center, and there were allegations that there was egg stealing going on and that there were also financial improprieties, and independent investigations took place and apparently found that these allegations had basis. And a whole set of cases were settled as a result of that. They were settled not under medical malpractice, but rather under negligence, fraud, concealment, and intentional infliction of emotional distress. I have to step back for a moment. You'll see from my reply that I have conceded my battery charge based upon the statute of limitations. I'm convinced by my opponent's presentation of the case that they put forward that showed another cause of action that did not toll for the battery charge, and I don't really have anything more to put forward with that, but I really do want to work very hard to convince you that the intentional infliction of emotional distress cause of action should not be dismissed based upon the statute of limitations.
Yeah, but that particular claim could be part of your damage claim, arguably in the medical malpractice case, couldn't it?
Not that I'm aware of. Not that I'm aware of. I mean, if I lose it, I will take your suggestion and see if I can do something with that, but I'd really like to preserve it. And the reason why I feel that I have a strong basis for this has to do with two cases from New York State, Dana v. Oak Park Marina from the 4th Department in 1997, and Long v. Sawandi from this court in
So
2006.
can I ask you, Ms. Fleischer, what is your allegation that the defendants experimented on your eggs, sperm, and embryos? What is that based on?
Yes, thank you for that question. I have put forward documentary evidence.
That your eggs?
Pardon me?
That your eggs were experimented on?
My donor eggs were, yes, if you look
What did
at
you
the
put?
record-
What did you put in?
I'm sorry?
What documents did you put in?
Yes, I put in a 2-page piece of research, published research,
That talked about your eggs?
not about my eggs.
Okay, I'm asking you because this is your claim. What did you put in that your eggs were manipulated or anything happened to them?
Yes, I don't have that pre-discovery, but what I am
Isn't
arguing,
it just that your surmise, because it sort of timing coincides with what occurred with you,
timing-
that the timing of it, you're assuming that that paper related to your eggs?
correct, and also based upon the fact that my medical records that the defendants had put before you are extremely limited, and I still have not gotten all of my medical records. But I did get enough of my medical records after I asked a second time.
Right, so is there anything in your medical records that show that there was manipulation of your eggs or the donor eggs
sperm.
or the sperm or
Yes,
anything?
Yes.
There is?
Well, yes, I had 3 vials of donor sperm that were donated on 2 different occasions. So some went to me and some went to many other recipients. I double-checked with the sperm donor bank. They had no quality issues with this donor sperm. 2 vials from 2 different donations, different times, from the same donor who had no quality issues were absolutely destroyed. And I mean destroyed to the point where the embryologist could not find a single motile sperm, and yet they went ahead and performed intracytoplasmic sperm injection on a dead sperm to see whether they could get this to fertilize one of my donor eggs. Of course, it didn't work. So that's what I have. And I would add to that, the record, page 470. This is the email from Dr. Zahir Murhi, who was basically John Zhang's right-hand man for a long time and left the firm right around the time that this research came out. And they got into litigation. And in the course of that litigation, he sent an email on January 29th, 2021, that was put into Scroll New York on February 15th, 2021, in which he explains that the reason why he left is that he could not tolerate the fact that Zhang was throwing patients' embryos, offering stem cells, and reverting to the nuclear transfer experiments he had been sanctioned for by the FDA earlier.
Okay, thank you. You'll have rebuttal time.
Thank you.
May it please the court, I'm Barbara Goldberg. I represent the defendant's respondents. I'd like to respond to an earlier question.
Let me ask you, in the face of the Court of Appeals decision in Carlin, how does the General Business Law Section 349 cause of action get dismissed? Isn't there enough alleged under the standards of Carlin to maintain that cause of action?
Your Honor, I would submit that even if we accepted for purposes of argument, and I'm not conceding it, but even if we accept for purposes of argument that the respondent...
I know you seek to distinguish it because of all of the awful things that went on in Carlin, but those things happened subsequent didn't they happen after the misconduct in that case?
I believe they did happen after the defendants were alleged to have committed misconduct in that case. But I think the key factor to distinguish this case from Carlin is that the plaintiff admitted that she went to our facility because all of the other facilities in the greater New York metropolitan area had an age limit. So she went to New Hope because it did not have an age limit. And also she was made aware, or should have been made aware by the numerous consent forms that she signed, that there was no guarantee of a pregnancy, there was no guarantee that there would be a successful birth, and she admitted in her complaint.
But the allegations as to deception are that you advertised or pronounced misleading success rates, both on your website and when you called on the phone while you were placed on hold, I think is another part of that allegation. So, I mean, and I recognize it's just a matter of pleading, but, you know, in the face of the Court of Appeals having allowed it in Carlin, I'm struggling to understand how we're not bound by that Carlin decision.
Of course, if it were directly on point, the court would be bound by a Court of Appeals decision, but I think that is a key distinction, that the plaintiff went to New Hope because there was no other fertility clinic in the New York metropolitan area that would accept her because of what she herself has described as her advanced maternal age. So ultimately, she did not rely on the supposed inflated success rates and the other advertising that she cites. She went to New Hope because it would accept her. And I think we shouldn't overlook the fact that her first cycle at New Hope did result in the birth of a healthy child. And I think to respond to Justice Friedman's initial question about the Carlin case, in that case, the fertility clinic was formally charged by the Federal Trade Commission with deceptive trade practices, and it had entered into a consent decree, but it kept making the same representations thereafter, and this resulted in it being charged.
You're talking about what happened in Carlin.
Yes.
But that's all stuff that happens after the treatment of the plaintiff in that case, right?
They sought treatment in 1987. You're correct. You're correct, Your Honor. The plaintiffs sought treatment in 1987, and in 1990, the Federal Trade Commission charged them.
You know, so when you read the Court of Appeals decision, it looks like it's relating all of that information to otherwise support what it's going to do in the case, but the defendant's conduct in that case has to be judged as of the time the defendant committed the conduct. And what the allegations are here, and I wish you would address them, what I did put forward in my complaint with respect to broad impact on consumers at large, and I'm reading from the plaintiff's reply brief, was a full thread of defendants' false, bolded text on their websites, a 98% survival rate for frozen eggs, up to 70% success rate for frozen embryos, so transferred, highest live birth rate, etc., and their phone message, 99% survival rate for frozen eggs. So is there some reason why those sorts of claims aren't enough to sustain a 349 GBL cause of action?
I submit, Your Honor, that because the plaintiff only went to the clinic because it was the only one in the metropolitan area that would accept her, that is not a sufficient basis for sustaining that.
But counsel, doesn't she plead both things? Doesn't she plead that she went, that advertising is one of the reasons why she went, and that she also went? I mean, this is a plead, that's a problem, obviously. This is a pleading motion, but you can't, I don't think you can deny that she did plead that those numbers deceived her.
But ultimately, the deception doesn't matter if there was no other clinic that she could go to.
Well, in the New York area, right? So maybe, I don't know, at the end of the day, it's going to be something else. But we're talking about a pleading matter, right?
May I just make one other point very, very quickly, Your Honor, because I think this is important to respond to an earlier question. It might have been a question by Justice Schulman. The question was whether the injuries claimed under the intentional infliction of emotional distress and these other claims could be recovered in the medical malpractice cause of action. And the answer to that is yes, and I would ask the court respectfully to look at page 70 of the record, which contains plaintiff's first cause of action for medical malpractice. And she said the alleged breaches proximately caused harm to plaintiff, including but not limited to severe physical and emotional distress, which harm is likely to continue into the future. So everything is compensable under the malpractice cause of action. And I would also respectfully refer the court to its decisions in BF against reproductive services and the Dennehy case, which was decided at the same time.
Thank you.
Thank you.
You know, I just have to say that I find it extraordinary that the opponents would suggest that just because I had no other choice, I deserve to be treated the way that they've treated me. I find that offensive for myself and for other people similarly situated. I appreciate Judge Friedman's raising the Section 349. It's not just that I saw these things on the website and heard them on the telephone message. When I spoke with the egg donor coordinator, she said to me in person, because I asked her, how many of the eggs should I fertilize from the exclusive cycle? And she said, our frozen eggs perform 98% as well as fresh eggs. That was the statement that she made to me that reinforced what's on the website. And based upon that, I chose to have only 6 eggs fertilized. She also said that they usually get half as many embryos as they have eggs. And I thought, surely, with tested eggs that are, you know, from a young woman's ovum, that's all I need. I would have chosen differently.
Of course, with the general business, though, we're not only concerned with what they may have told you, it's whether there's a deception which has a wider impact, which
Absolutely
is
so.
necessary in order for
Absolutely
that course
so.
of action to be
And
sustained.
I've searched, and I'm afraid I can't quite find it, but I do make reference in my complaint, it's on the record, to a lawsuit against Zhang Medical et al. From an operation called Terry, T-E-R-R-I, ampersand, Sandy Solution, in which they contracted for $750,000 for advertising. A friend of mine saw one of their billboards on the side of a city bus stop in New York City. They used the windows at 4 Columbus Circle to advertise their egg freezing. This is sent out to the public. This is consumer activity. It wasn't just directed at me. It was directed to the public at large, or the public at large who needs fertility services as we are growing in numbers as time goes on. So I do appreciate Judge Friedman's bringing that
I mean,
up.
it's a matter, we're bound by what the Court of Appeals says, and you've got the Carlin decision, which seems to favor your position, so.
Yes, indeed it does. And, you know, no other fertility clinic. I did find out that there's a clinic that has an office in Albany, CNY Fertility, and this is where I went then after I came away from Zhang Medical after 2 years of hellish treatments, spending another $60,000 that I borrowed against my retirement accounts. And I went there, and in very short order, I was able to conceive a beautiful, healthy baby girl. There is no reason why the defendants couldn't have done that for me had they not operated in good faith on any number of levels. Thank you.
Thank you. Caputo versus IESI, New York Corp.
Good afternoon. May it please the court. Jessica Pizzatelli and Littler Mendelson on behalf of appellants IESI New York Corporation, Charles Mahoney, and Frank Lino. Appellants respectfully submit that this court should reverse the Supreme Court's decision in order which denied appellant's motion for summary judgment. Well, the Supreme Court held that there were issues.
It boils down to the increased sales goals, right? Because that's what happened here, right? I mean, shortly before he's not shortly before, but after he was called out about being out sick, he got his sales goals got increased. So what he had, the targets of his sales goals. So why isn't that discrimination of his, assuming there is a disability with the kidney stone, why isn't that discrimination? And also, why isn't the fact that he brought it to HR's attention that his termination was retaliation and not tied to not meeting those performance goals?
Certainly. So I have a couple of responses to that. One, you don't even need to get to the sales goals because he didn't establish that he had a disability. He didn't establish that and that's with respect to the disability discrimination claim. He didn't establish that he engaged in protected conduct with respect to the retaliation.
Let's assume he did.
Assuming he did for purposes of argument.
Right. For purposes, how is a sales goal not, how is it that wasn't discriminatory?
It wasn't discriminatory because too much time had passed in between the August 2nd kidney stone issue, the early August complaint to Human Resources that he thought his boss thought he was lying. And then 5 months later, his sales goals are being increased. There's no temporal proximity there. We have cited 10 cases in our brief, I think at least 3 or 4 from the first department, which have held that when there's a time period of 2 or 3 months or less or more, that you can't find temporal proximity.
But he wasn't the only one. All the salespeople had goals increased, correct?
Absolutely, absolutely.
Some even higher than his.
Absolutely. I couldn't agree with you more. And so we've also put in, you'll see that Mr. Caputo has put in his papers, he has quoted Mr. Mahoney as saying sales goals were based on prior year performance. We agree. And if you look at his prior year performance, he had $74,000 in sales. His 2017 goal set at $78,000. Mr. Mahoney testified, he cites in his paper that the prior year sales goals are considered with a minor reach goal to make sure that you are striving to improve the business. We need to meet sales budget. We need to meet district budget. And so the elevation of his sales goal completely followed and tracked exactly what the witnesses said was how sales goals were set. And that's absolutely correct. At least 2 territory managers had sales goals set that were higher than Mr. Caputo's. And so you cannot find on that record that the elevation of the sales goal was either an adverse employment action or discriminatory in any way as a matter of law.
And as to damages, he is doing well in his new company.
He's doing very well. His pay has increased year over year. He was promoted to a manager position. And the owner of the company and his current employer testified at deposition and said his job has never been in jeopardy here. We never considered firing him. He's been performing business as usual, is I think the words that his boss used. So he hasn't suffered any damages. It just, as a matter of law, he has no claim here. He has no discrimination claim, he has no retaliation claim, and he has no tortious interference claim. And I'll rest on my papers, but the points I wanted to make at oral argument were, one, as a matter of law, he has not established that he has a disability. I'll rest on my papers.
I think there's case law out there that, in the temporal, or at least, something that comes and goes real quick is not considered as disability.
That's absolutely right. And if you accept his position, then you are creating an incredibly dangerous precedent that anything.
Oh, human rights law. I mean, we've got precedent that says it should be given expansive reading, and it should be, it's sort of a work in progress, as they say, right?
But I would also submit that a half-day kidney stone, I mean, where do you draw the line then? A bloody nose, a stubbed toe, an upset stomach? You have to draw the line somewhere, and the courts have done that. And they've said a transitory condition, and they've addressed transitory conditions that were much, much more severe than what he is even alleging here over a period of 10, 12 weeks, where people have suffered, been recovering from surgeries. He just simply hasn't alleged that it's such a dangerous precedent that he's arguing for, that if you accept that argument, then literally any employee who is out sick for half a day will be arguing that they have suffered a disability, and that is not the law.
Great. Thank you.
Thank you, Your Honors. May it please the court. Tom Sotilli for Respondent Caputo. The court should affirm the denial of...
So why is it that not even a day
in terms of the kidney stone, should that be considered a disability under the human rights?
As you correctly noted, Your Honor, there is no case law that imposes any kind of durational or severity requirements on illnesses in order
But
to
we have
constitute-
case law that have found no disability in more extreme cases, right? Where the claim or the injury or what was claimed, the condition didn't amount to a disability, right?
We have explicit case law that says, quote, this is Ruiz versus United States Parcel Service that we cite in our brief 173 NYS 3D 901. Whether plaintiff's injuries are permanent or temporary is not conclusive for a disability to be eligible for protections under the city human rights law. There is simply no precedent that this
Okay.
court could use to invoke.
So let's assume there is a disability. Why is this new performance target discriminatory? Because this is based on his past performance. He hit a number, so they decided, as any employer, I'm going to raise that number to incentivize you to get a higher number. What's wrong with that?
Appellants focus on the gross numbers here, at least today they focused on the gross sales. It's about the percentage increases and what Caputo could have been reasonably
Didn't
expected.
some others get even higher percentage increases?
No, Caputo's was the highest percentage increase at 67% in his district. The average percentage increase in his district was 27%. I think the next highest was 40%. So it's not about the gross sales, who had the most existing business prior to the sales goals increase. It's about what a performer could reasonably reach. Now, I want to focus on the temporal proximity here because Caputo takes medical leave. He has a diagnosis, goes to the hospital, has his kidney stone diagnosed. He produces those papers to his employer the next day. The very next day, the employer makes a derisive, sarcastic comment about his illness, which alone is enough to lead a reasonable jury to conclude that discriminatory animus played some part in the decision to fire him and to increase his sales goals, which is the standard.
Is there anything discriminatory if the supervisor had thought, this person left as an emergency to the hospital, and it seems sort of odd to me that he's at a baseball game at the end of the day. Now, of course, it's possible, as is the situation here, but there's nothing discriminatory, is there, in the supervisor thinking, I've been had?
No, it's discriminatory to make derisive comments about an illness and then within months.
Well, it's not
increase his
derisive
sales
comments
goals.
about illness. I mean, wasn't the point of the supervisor's comments is you've been inaccurate in what you've told me, that you really didn't need to go to the emergency room. What you wanted was a day off. Now, that may have turned out to be, he may have been completely right that he did need the emergency room, but is there anything discriminatory in the supervisor initially having that reaction?
That judgment is for a jury to determine at trial, and I think it would be helpful if I could just zoom out a bit here and talk a little bit about the standard, because I feel like we're getting lost in the weeds. The question on appeal is simply, under the New York City human rights law, whether a reasonable jury could connect these dots and find through any evidentiary route whatsoever that a discriminatory animus played any role whatsoever in his sales goals increase and termination. Now, the flip side, the other side of that is that in order for appellants to prevail, there must be no evidentiary route that could allow a reasonable jury to conclude that discriminatory animus played any role in the decision to increase Caputo's sales goals and ultimately fire him. And we submit that the temporal proximity between his complaint, his leave, his illness, his complaint to his boss, the increase in his sales goals, which happened in a matter of months, and then the pretextual written warning and expectation letters that held him to a standard that was not reasonable for him to meet, constituted discriminatory pretext based upon his protected disability.
What was his disability after that one day?
It was the kidney stone was the disability.
That was resolved, right? Because he went to the game that night, so we assume that disability was resolved.
That's not really.
And then, so when he gets months later, when he has 100 and he's performing 167% above, and his sales goal gets raised accordingly, what is the disability?
The disability was the kidney stone that his boss perceived as something that should not have allowed him to go to this game, that in other words made his boss angry, that caused the boss and the supervising boss in the company to retaliate against him.
Okay, thank you.
like to address just a few points. The derisive correspondence that's referenced was a single email where the boss.
So your colleague says that the plaintiff's sales goals were increased more than any of the other employees. But is it also true that plaintiff outperformed his 2016 goal to a greater extent than any of his co-employees?
I would have to look at the record, Your Honor, but to address that percentage point and performance point, even if you look at Mr. Caputo's own brief, and the brief that they submitted the appellate division, he quotes Mr. Mahoney, and he quotes Mr. Mahoney as saying it's not a percentage metric. What we do is we look at prior year sales goals, and that's how we set. We looked at 2016 goals, and that's how we set 2017 goals. And Mr. Mahoney actually testified about this exact issue at deposition, where he says that the sales goals were based off the prior year sales, and then we added a stretch goal on top of what their prior year sales were, and they were different for each salesperson. And if the salesperson had a great year, then their goal may have gone up more, and if they had not such a good year, their goal may have gone up less. But to address the percentage point, Mr. Mahoney also testified we did not use percentages. We used dollars, but year-over-year sales. And if a salesperson had a lower starting point in 2015 or 2016 than the salesperson in the same job, then his sales may have gone up by a greater percentage.
So was there
Starting at a
anything,
lower sales number.
let me just interrupt you. Was there anything that you did that was different for the plaintiff than all the other?
Absolutely not.
Everybody
Everyone
got
was
that
treated
same-
exactly the same. They looked at prior year sales goals and used that to set the 2017 goal.
Okay, thank you.
Thank you.
All right, People versus Pernell Liebert.
Good afternoon, Your Honors. Stephen Strother from the Office of the Appellate Defender on behalf of Pernell Liebert. I'm going to address two claims today. The first is the pretrial hearing on Mr. Liebert's alleged statement to Detective Kill, and the second is the predicate felony claim. As to the first, this should be reversed because the prosecution didn't meet its burden. It put forward no credible evidence showing that Mr. Liebert made a voluntary statement. And for that reason, it should never have been admitted on rebuttal. The sole alleged witness to this alleged statement, Detective Killen, I'm going to walk you all through the timeline of what happened here. 16 months before the suppression hearing, Mr. Liebert was interrogated for 9.5 hours by Detective Vasquez, the lead detective. He does not make any inculpatory statement. He requests a lawyer. Allegedly, Detective Killen walks in and asks him one question, at which point Mr. Liebert allegedly confesses. Detective Killen says nothing to anybody for 16 months. There's a suppression hearing on the statements that Mr. Liebert gave to Detective Vasquez. Those are suppressed. The next morning, the prosecution walks in and says, oh, there's an inculpatory statement from Detective Killen that he never told anyone about. Detective Killen testifies and says, talks about the statement, and then he says, oh, I also told Detective Vasquez about it too.
So, counsel, wasn't that up to the court put it up to the jury? You can decide whether or not that's true, correct? And that's what the Court of Appeals has said in that situation. The court initially found, one, that the statement was not a confession, although I know you've said that. He said something else. He said that they didn't know that I had a gun in the car. And two, it was up to the jury to decide. Once your client got on the stand and gave a story that completely disagreed with all the other witnesses, the people are entitled to put that detective on and let the jury decide, and they obviously did, right?
So I disagree strongly that Washington, that's the case that the prosecution's on, that is what Washington holds. Washington does not alter the rules at a pretrial hearing for assessing testimony. It is the prosecution's burden to show beyond a reasonable doubt through credible evidence that there was a voluntary statement. People versus Carmona, 232, 82nd, 144. The testimony must be credible, and it cannot be credited when it is contrary to
Even if it serves
experience.
for impeachment purposes?
What's that?
Even if it serves for impeachment?
For all pretrial hearings, the prosecution still bears that burden. Washington does not
The
speak.
trial judge found Detective Killen credible, didn't he?
You mean the hearing judge?
Yeah, the hearing
Yes,
judge.
he was wrong, because there is no way that this testimony is...
Well, you say it's incredible as a matter of law, but the trial judge heard Detective Killen and believed Detective Killen.
Yes.
And then left it for you to go back and present the issue to the jury.
Yes, I think our argument, it's true that the trial judge didn't think Detective Killen was credible, but the point of the law on when testimony is so manifestly untrue and contrary to experience is that this court can substitute its judgment for that court, and it should in this case, because no experienced detective wait 16 months until after the day of a suppression hearing to spring an inculpatory statement on the defense. Then he testifies he told all the other detectives who also didn't write it down and report it. Instead, they only reported exculpatory statements that they testified about. This flies in the face of any police conduct about revolving statements. And the point here is that
Presumably you had an opportunity to ask Detective Killen about this in the hearing in front of the hearing judge, and you certainly had the opportunity to bring this out in front of the jury.
Yes, Your Honor, but just because those opportunities...
And what was Detective Killen's explanation for his failure to tell anyone?
His explanation was, no one asked me. Detectives are not supposed to wait until someone asks them to report an inculpatory statement. He's on the case. He's supposed to make a DD-5 of it and report it to them. He also said he did report it to Detective Vasquez, who never told anyone. He testified the day before at the suppression.
So what he told Detective Vasquez is that you'll never get a statement out of the defendant?
Yeah, well, actually, Detective Killen tried to coach him to get a statement out of Mr. Liebert, who didn't give one for 9.5 hours before that. Another reason why we think that there's significant reason to doubt Detective Killen's testimony. And also...
Isn't that the issue here that you run into, that there may be, you make a very reasonable presentation about how it would seem to me that if I was in the position of that detective, I would want to report that statement right to the prosecutor. But can we really say that's a matter of common experience? I myself have never been a police officer. I don't know how their standard operating procedures. This could have been sloppy police work. So it really doesn't it really boil down to, it's not reasonable what the officer is testifying to, and so jury don't believe him, as opposed to us saying, well, we think the better practice would have been for the officer to report the statement right away.
But it's not about whether the jury should believe him. It's about whether the hearing court should believe him or to believe the prosecution met their burden.
So essentially what you're saying to us is that we should make that credibility determination here?
I am saying that there are multiple...
I mean, everything that you're arguing to us, you argued, not you personally, but the defendant's attorney argued before the trial court, correct? Or the hearing court, correct?
Yes, those are correct.
And the court, and the hearing court, who was right there listening to the testimony, found something different. And you're asking us to change that as a matter of law?
Absolutely, because it has happened in multiple cases in the past where the officer's testimony is far beyond, when it beggars belief and it doesn't merit belief. Now, I'll quickly transition, to the sentencing argument. I'd like to say a couple words about it in rebuttal, if that's okay.
On rebuttal, yes, thank you.
Good afternoon, Your Honors. May it please the court. My name is Sheila O'Shea, and I represent the respondent on this appeal. Contrary to my adversary's argument, Washington firmly controls this case. I think the scenarios were essentially identical. In that case, the Court of Appeals recognized that any dispute as to whether the defendant made the statement is a factual matter for the jury to decide. And in that case, the suppression judge had essentially said he discredited the statement, nevertheless permitted
Discredited the police officer's statement, but right.
Yes. Right. So here, and look, it was whether or not he followed police protocol, and perhaps he didn't, and I think it is somewhat odd that he waited so long and perhaps didn't notate this in a DD-5, but again, that's an issue for the jury to decide. I think the case law on that is clear. This
was a serious crime. This was an inculpatory statement. I mean, from a common sense perspective, it seems like the sort of thing a detective would want to tell the prosecutor, his fellow officers, right away. This wasn't some petty crime or a seemingly innocuous statement. This cut to the heart of what they believed the crimes the defendant had committed.
Well, in fairness, Killen was investigating the homicide case, so the statement wasn't of particular use to him in that. I think he deemed it. I think he explained that he thought it wasn't particularly
Was
important.
that because there was no question that the defendant was incarcerated at the time the person was killed in the homicide?
Right, so the defendant could not have been a suspect in the homicide case because he was picked up almost immediately after the crime, which happened at midday. There was really no break in between the events of the shooting and his arrest. So
let's get down to the core of defense counsel's argument. What is your explanation within the record for Detective Killen not having reported this to the district attorney, not having prepared a DD-5 for it?
I think he said he didn't think the state was important, and he also said, as I think has been noted, that he wasn't asked about it, which admittedly is not a good reason for not proffering.
Because defense counsel makes a very effective argument that this is how could this be? I mean, if this is true, how could it be? And I'm wondering what your answer is to that.
Well, my answer is that it doesn't really matter because under Washington, it's a credibility question for the jury to decide. And again, I think this case is on all fours with Washington.
I mean, like you said, in Washington, I mean, the trial court found it discredited. I mean,
Exactly.
So here the argument is flatly incredible. Flatly incredible is not as bad as totally discredited.
And as Justice Friedman pointed out earlier, the court did in fact credit his testimony. He noted that he'd been a detective for 23 years, et cetera, et cetera.
I'm just assuming that if he were arguing that this, is so incredible as a matter of law that you should toss it out. Well, that's not as onerous as what a trial court actually said.
That's the point I'm trying to make,
Right,
Your Honor.
it's totally discredited, but it's still, according to Washington, it still goes to the jury to decide.
Right. So I think it's well settled law that this is a credibility issue for the jury to decide, and I think the judge properly decided that it needed to go to the jury. And may I say on the voluntariness, which was the issue before the court, the defendant certainly never argued that there was any coercion. In fact, the evidence showed that the defendant was not handcuffed. The defendants did not have their guns drawn. Killen never said anything, never made any threats or promises, and the defendant never said he refused to speak to him. So on the voluntariness issue, which is a separate issue, right, the judge correctly decided that the statement was voluntary. And that's really what was before the judge. As I said, she properly decided that the other issue was the credibility of Killen's testimony was an issue for the jury.
Just briefly, what is your response to the argument that the sentence here was excessive? Because that's what your friend's going to get up and argue on.
Well, first of all,
it's a 22 years to life.
Right, but I think the maximum was 25 and the minimum was 16.
And he got an offer of 14, right?
I don't recall, Your Honor.
The offer
was 14
years.
Well, it's not unusual that there's a discrepancy between offers and
Is
sentences after
8
trial.
years?
It's less than the maximum. He got concurrent time on the various crimes.
So what is your response to him saying that he should have a reduction to 16 years?
I'm sorry, Your Honor?
He wants a reduction to 16 years. What's your response to that?
My response is that this was a fair and appropriate sentence and that it should not be disturbed. Thank you, Your Honors.
Thank you.
Make one quick point about Washington and then talk about the predicate felony argument. The problem with this interpretation of the Washington case is if you hold what the prosecution's arguing, you're holding that a judge at a voluntariness hearing cannot find a detective not credible.
Can you
And that's
address
not the law.
Can you address your excessive sentence argument?
Well, actually, I wasn't going to talk about excessive sentence. I'm going to talk about the predicate argument. I believe this has to be sent back for a second felony determination. His plea when he was 18 was not valid. Now, an excessive sentence, I think the issue is that he was the victim of an armed robbery in this case that's conceded by the prosecution. Now, did Mr. Liebert make a good choice? We would never say that he did. But what we would say is that nobody was hurt, that he was also the victim of a crime, and that he got 8 more years after trial than he got on the plea offer before trial. That's a very large gap of nearly a decade. And I think that Mr. Liebert, and we also outlined a little bit in our brief, became a father while this case was pending, and I think that gives him a very significant reason to change his behavior when he gets out. And I do not think he deserves more than 2 decades in
The
prison.
fact that there is, the record has that that he was trying to suborn perjury. I mean, doesn't that factor into an analysis of whether or not the sentence?
Well, obviously, as we argue in point 1 of our brief, we think that that he was not trying to suborn perjury. He was trying to locate people in his neighborhood that had witnessed the crime. He even named someone who he thought he saw on the street to go find him and testify. And they keep talking about suborning perjury, but the guy he's on the phone with the whole time to help him find people never asks him to come testify, never says, hey, come lie for me. None of that ever happens. So I don't believe he was trying to suborn perjury. I think that's what the prosecution wants this court to believe. What's that?
I listened to the tapes too. Okay.
Oh, I'm sorry. So we do think the sentence should be reduced to 16 years to life because that's what a crime would be.
If you accept the jury's verdict, of course, the defendant testified in a perjurious manner, didn't he? If you accept the jury's verdict, then the defendant's testimony was perjurious.
Well, Your Honor, I don't think we can say that every sentence is justified every time a defendant testifies and the jury convicts them, because that
Clearly not. Clearly not. I'm just saying that's another hurdle that the defendant has in terms of his case, isn't it?
I'm not going to sit up here and say that
He was convicted
Mr.
of
Lieber committed
attempted
perjury.
assault, right? Not, he was convicted of attempted assault. He wasn't convicted of the most serious crimes, and there were two.
That's
correct. There were 2 points where the jury was deadlocked, right?
That's correct. I mean, it was a very, very close case because they didn't have any video of so much video, but none of it Mr. Liebert's holding a gun. They don't find a gun. There's also a video that we think shows an alternative perpetrator.
You're talking about the video where there are 2 people running down the street and then someone towards the end of it goes like this, right? Puts his hand towards the back.
Actually puts it back in the position of a person holding a weapon.
Puts it over his shoulder, not that he stops and turns around to shoot, but those are people running away from the defendant, are they not?
Well, you could also say they're probably just fleeing from the scene
got
of a
the
robbery
gun-
they just committed.
If they've got the gun, why are they running away from the defendant?
Well, because they just committed an armed robbery in broad daylight in front of people, would be my guess.
Got it. Thank you.
Yeah. Thanks. Take care.